Good afternoon, everybody. My name is Rob Leverett. I'm chairman of the House Rules Subcommittee on Lawsuit Reform, and I appreciate y'all's presence here today. We've had 2 meetings already. This is our 3rd one, and we're here today to discuss Section 6 of Senate Bill 68, which is on negligent security claims, and at least I think that's how it's styled. We've got quite a few witnesses. Today I was going to let those opposed to the bill go first, and I've got 26 people, or 25 people signed up to testify against. So I want to give you some opportunity to speak, but given the number of people, of course I'm going to have to limit the time you can talk. We generally allow an hour for the testimony, and we also have questions. So my intention was to limit you to about 3 to 4 minutes of your testimony, and then we'll have questions for you as well. Representative Evans, did you wish to be recognized?
Yes, thank you, Mr. Chairman. I just wanted to clarify for those that are here to speak. I wanted to ask you. I assume it's like last hearing where we were focused on certain sections, but we will hear what the people want to tell us.
Yes, that's true. Okay. That's true. If you, as the notice said, if you don't get the notices or don't read the notice carefully and you want to talk to some other section, we'll hear from you. But again, I would ask you to limit your testimony and just be mindful of that we have a lot of folks who want to testify today. We want to hear from everybody, but we might not necessarily be able to hear from everybody at length. So I'm just going to proceed through the list here and kind of get going because I think we're going to have a long day. So the first person to sign up was Meredith Watts. Good afternoon.
Good afternoon, Chairman. Thank you. My name is Meredith Watts. I'm an attorney with Brooks Injury Law here in Atlanta, and for the last years, part of my job there has been helping victims who have had horrible, catastrophic injuries occur, or the families of people who have died on commercial properties around the state of Georgia.
Ms. Watts, if I can interrupt you, you're projecting beautifully, but I don't sense the microphone is picking up very much. Can you try pulling that a little closer to you?
Okay, is that better? Is that better? Okay. Sorry, I haven't done this before, so.
Well, and the equipment isn't necessarily the best. You're like, as I say, I don't think anyone's having a big problem hearing you, but I just didn't sense the mic was picking up. So please continue. I'm sorry.
Okay. I've also served as an appellate attorney for the last 19 years of my career, so I'm intimately familiar with how the Georgia appellate courts interpret the statutes that this legislature passes. I'm not just a lawyer. I'm a mom of 2 boys, ages 8 and 12, we live in the city of Smyrna, and I'm here today not just as a lawyer, but as someone who is concerned about safety. And I know everybody else here feels the same way. And so I want to talk just a little bit about what the current state of the law is in Georgia for these negligent security cases. We have our general premises liability statute that says that a property owner has a duty to exercise ordinary care for invitees that come on their property. Now, the default rule for negligent security is actually, I think, might surprise some folks. The default rule is that under this premises liability statute, property owners are not the insurer of an invitee's safety, and that generally there is no liability for someone getting shot, for example, on their property. Now, the duty arises only as an exception when a property owner has sufficient reason to anticipate criminal conduct. So the test right now is reasonable foreseeability. Is it reasonably foreseeable that someone might get shot on my property? If so, then there is a duty to do something. Now, even if this duty arises, that doesn't necessarily mean that a property owner is going to be liable if someone gets shot on their property. If they have reasonable security measures in place on that property and someone still gets shot, which could happen, they're not going to be liable under the current structure of Georgia law. So the current structure actually strikes a great balance between protecting the citizens of Georgia and not overburdening property owners with too much responsibility. And we actually turn away a number of cases when people come to us and they've been shot on someone's property, and we run a check and we say, well, we looked and there wasn't really any crime going on this property, so it's horrible what's happened to you, but this property owner wouldn't have had reasonable foreseeability that you might get shot, and we can't help you with this. And so I want to next, I know time is short, so I'm trying to abbreviate this, but the current statute, the 51-351, this deals with invitees on property. These are people that have some kind of commercial. They're at a Walmart, they're at a McDonald's, they're at an apartment complex, they're at a gas station. And some of the unintended consequences of this language that I don't think anyone intends to happen, but very well could happen, when we look at this language in line 225, talking about this exploiting a specific physical condition of the premises known to the occupier. This is significant. This could be interpreted, and I think people will exploit this in the appellate courts to say that someone, now the crime is not just that they went to the McDonald's and there was a lack of security. There was 8 shootings and there was no security whatsoever. I think the property owner in that case could say, well, there wasn't an exploitation of a physical condition of the property. This was just, there wasn't any security. So this actually, as it's written, I think could encourage property owners to do nothing. They could say it has to be a breach of a gate. The gate was left open and somebody got in. There's a hole in the fence and that's how they got in. So this specific physical condition of the premises language, I don't think anyone intends for this to limit out cases where people have knowledge that all this crime is occurring on their property, but it wasn't a breach of an actual gate or a fence that caused the crime to occur to the particular client. This later language in 227 and 228, this substantially greater than the general risk of wrongful conduct in the vicinity of the premises. I've been doing this for a lot of years, and I don't know how, I mean, that's not even defined of how you would even prove that. I think that's going to limit out a lot of cases, and what this is going to do is basically immunize property owners from having any responsibility when they know that crime is occurring on their property, and they don't do anything to protect people coming on their premises for a commercial benefit too. You know, we've had cases, we had someone get shot at a commercial property, and we went to go look at that commercial property after the shooting, and what did we see in the parking lot afterwards? A cop car. They were paying off-duty police officers to come now and secure their premises. It's not a huge expense, and it's something that people can do, and then they're not liable under the statute if they're at least taking some measures. So we provided in the slides, some slides and a red line of the bill that would address this language that would be problematic, and I think that people will use to try to insulate property owners and immunize them. It's this specific physical condition of the premises language and the substantially greater than the general risk language. We've got it struck through in this. It's not a whole lot of changes, but those changes are important to strike a good balance between not overburdening your property owners, but also protecting the citizens of Georgia.
Thank you. And is this
So there, that it came with those are the slides, and then yes, the red line is attached to it, and we've just kind of struck through that language that we think creates this loophole that people can use to basically immunize all of these property owners.
Okay. So for committee members, that's this sheet here.
Right. Yes, there's a packet of slides.
Changes, and then there's also a separate sheet that is formatted like that. And
yeah, so sorry, it's a little confusing because I forgot a section. So on the first page, you know, in line 189, there's the specific, and then 190 physical is taken out, and then starting 191, that is substantially, the rest of that is struck, and that's the similar language that we're taking out of 225, 227, 228, and then the word physical in 230.
Are the changes shown on this handout?
No, so that is the current law. In the handout, sorry, it's a little confusing now that I'm looking at it all. So in the handout, the first handout with the slides, that is the current law, and we have circled this language that we think is problematic. And then in the second handout, this is going to be our red line where we've struck through the language that we think needs to be taken out to ensure, you know, that all of negligent security cases aren't going away with this.
So in other words, this handout highlights what you
Just
view
more-
as the
yes, that's
problem, and this
informational.
proposes a solution.
Correct.
Okay, all right, just for members of the committee so you can kind of understand. All right, you got a question?
Did you say Miller? Oh, thank you. Thank you. I'm sorry, Mr. Chairman. I have a question about your proposed amendment. You make a couple of strikeouts around the knowledge component. So, like, for example, I'll go to line 213. You didn't do it here, but I'm wondering if is it knowledge or is it should have known? So do we want property owners to, right now, let me start over. Is the current state of the law that the property owners have to specifically know? How do you prove what's in someone's head? Or is the law that they should have known?
I actually think the answer to that, there's a little bit of debate between lawyers, I think, on that issue. I think when I read the case law that the Court of Appeals and the Georgia Supreme Court have required actual knowledge by the property owner that these crimes were occurring. This should have known, I think, is something that kind of makes sense, because we've had an apartment complex where the property owner, there was so much gang crime going on, like they had to leave. They didn't have any management left on site because no one would work there. And so in that case, like, do we want it to be that you can just immunize yourself by saying, well, I don't know. I left. I don't have anybody on that complex, so I don't know about the crime that's going on there. I'm not liable. I don't think that's how it should be, but I do think that the current case law interpreting negligent security law is that you have to prove that there is some knowledge on the part of the property owner that these crimes are going on.
We'll follow-up question, just one.
Sure.
So the concept that you're referring to is something we call willful ignorance or willful blindness. And
Sure.
I guess, would it make sense to clarify the law so that the knowledge element is more clear, knew or should have known, which would then encourage landlords or absentee landowners not to pretend or shield themselves from knowledge to deliberately evade being responsible for what's happening on their property?
Sure. I mean, that's definitely something that could be considered. I do think that the law should not be written in such a way to encourage willful blindness as you're talking about. So, if there'd be a way to work that in, I do think that that's important. But I do think it goes in litigating all these cases. You might get the corporate representative to testify at their deposition. They're like, we had no idea what was going on here. And then you depose the property manager and they're like, well, yeah, I did kind of know. So, I mean, we've found that even when people say we had no idea, we do find employees that are talking about it. We find emails that are talking about it. We find incident reports that are talking about it. So generally, even when there is kind of this defense of we had no idea this was happening, people do know what's going on, and they're just not doing anything in response to it in the cases that we're taking the distance and taking to trial.
Thank you. Any other questions for this witness? I don't see any other questions. Thank you very much for being here today. All right, Michelle, is it Maggard? All right, Ms. Maggard, when you're ready.
Thank you, Mr. Chairman and members of the committee. My name is Michelle Maggard. I am a licensed professional counselor in the state of Georgia, specializing in trauma recovery, and I have been for over 19 years. I have worked at the DeKalb Rape Crisis Center for 13 years, and I'm now in private practice at Avondale Counseling Services. I come before you today as a therapist who has spent years working with survivors of sexual assault, guiding them through the immense emotional and psychological toll of their trauma. I have witnessed firsthand the devastating impact that violence leaves in its wake, not just in the immediate aftermath, but for years, even decades after the event. I urge you to amend SB 68 as it would place insurmountable legal and emotional barriers in front of survivors seeking justice and healing. One of the most crucial aspects of trauma recovery is ensuring that survivors feel safe and that justice is served. Under the current law in Georgia, property owners have a duty to exercise reasonable care, which, as I understand, it means to provide basic security measures to prevent foreseeable crimes, including sexual assaults. SB 68 would effectively eliminate this responsibility, shielding landlords, businesses, and institutions, even those with a known history of violent incidences, from being held accountable, unless the survivor can show there was a physical condition causing a substantially greater risk. This is a particularly troubling for businesses whose sole existence is to keep vulnerable people safe. daycares, schools, nursing homes, etc. I have worked with survivors who were assaulted in apartment complexes, hotels, and other businesses that lacked even the most basic safety measures. Their sense of betrayal is compounded when they learn that their assault could have been prevented if only the property owner had taken reasonable precautions. By removing these protections and accountability, SB 68 not only denies survivors justice, but also increases the risk of future assaults. We are talking about grandmothers, sons, wives, daughters, and children, real people who deserve protection under Georgia law. Many of my clients struggle financially due to the aftermath of their assault. Some are unable to return to work, while others require costly, long-term mental health care. When negligent businesses and landlords are no longer held responsible, these financial burdens do not disappear, they simply shift to the survivors and ultimately to taxpayers. Instead of making survivors fight an uphill battle for justice, we should be working to ensure that they receive the support they need to rebuild their lives. SB 68 is not about fairness. It is about protecting negligent corporations at the expense of crime victims. As someone who walks alongside survivors every day, I cannot stand by and watch this bill pass without speaking out. I urge you to amend SB 68 to protect survivors of sexual assault and other violent crimes. I know this hearing is focused on the negligent security section, but while I'm here and able to testify, I want to mention two other items of serious concern in SB 68. Survivors of sexual assault already face enormous barriers when seeking justice. Many struggle with PTSD, depression, and severe anxiety. SB 68's requirement for multiple trial phases will force them to relieve their trauma repeatedly. First, to prove liability, then to argue for damages, and potentially again for punitive measures. Each time they testify, they are forced to reopen wounds they are trying desperately to heal. From a clinical perspective, this process is deeply harmful. Many survivors work hard to regain a sense of control over their lives. Forcing them to endure unnecessarily prolonged legal battles increases the likelihood of re-traumatization, worsening symptoms such as nightmares, flashbacks, panic attacks, and even suicidal ideation. As a therapist, I have seen clients drop out of legal proceedings simply because the emotional cost was too great. This bill will make that even more common, ultimately barring survivors from civil justice because the deck is stacked against them. Another disturbing provision of SB 68 is in Section 1 and the restriction on attorneys discussing financial damages with prospective jurors and jury selection. For sexual assault survivors, financial compensation is not just about money, it is about affording the anticipated but sometimes unknown costs of therapy, medical care, lost wages that result from their trauma, and be with them for the rest of their lives. It is about recognizing the full extent of the harm they endured, harm that never should have been allowed to happen. Practically, if survivors' attorneys are unable to question the juror panel on biases around non-economic damages, this will ultimately reinforce the harmful societal message that sexual violence is something survivors should simply get over, rather than an event that causes lasting psychological and financial damage. I come to you all today as a professional speaking for many who I know cannot speak here today for themselves, people whom it would do more harm than good, people constrained by confidentiality provisions. I also speak to you as a former Rape Crisis Center counselor on behalf of Georgia Rape Crisis Centers and Child Advocacy Centers across the state that I understand are concerned that speaking out against this bill could have political backlash or even result in funding cuts to budgets they desperately rely on to serve the people they so selflessly support. Finally, I come to you as a mother who relies upon you all to make this law better for those I love and those to whom I've devoted my career. The trauma of sexual violence is already a heavy burden to carry. Please do not add to it by stripping away the legal protections and support the survivors desperately need.
Thank you, ma'am. Any questions for Ms. Maggard? Oh, I see Chairlady Miller.
Thank you. Thank you so much for your testimony today. I am a former sex crimes prosecutor. Is it your experience, I know it has been my experience, that it is very difficult sometimes to even prosecute these cases because victims of sexual assault are that re-traumatized by having to re-talk about the story over and over again in front of strangers? Has that been your experience? And I guess your thought is that the provisions of this bill requiring 2 or 3 potential attacks on cross-examination of a sex assault victim would do more damage to these folks who are already vulnerable and suffering extreme mental sort of distress.
as they come in and get the help that they need, we try to support them as much as possible. And then each time when they have to go back to court to testify, to tell their story, each time it's re-traumatizing again. It's re-victimization again.
Thank you. Thank you, ma'am. Thank you for your testimony. Michael is it Rosenberry or Roseberry? Roseberry. And the first name is? Michael. It is Michael. Okay, all right, good. I thought my fellow committee members was chiding me, but I thought I'd pronounced it correctly.
Nope, it's like the boy's name. So my name is Michael Roseberry, and I am a survivor of trafficking. I remember the first time that I ever had a gun held to my head. Truthfully, my memory often haunts me more than I allow it to show. The first time a gun was held to my head, I had a man who was about 3 times my size wrap his hands around my throat. With one hand, I remember feeling each of his fingerprints pressing against the side of my throat, and with his other hand, holding the barrel of a gun against my temple. What struck me most about that moment was not necessarily the fear of it. While the fear was great, the lack of control was much greater. The feelings of being disvalued and undignified are the feelings that last a lifetime. The fear subsides. This was only the first time, but it was not the last. I was only 19 years old. Other people my age were in college, going to football games, meeting friends for late night study sessions, and figuring out who they wanted to be. I wasn't old enough to buy alcohol or cigarettes, but I was old enough to be bought and sold by perverse men. While my peers were experiencing life, I was experiencing trafficking. I remember sitting in the back seat of a car, my scalp bleeding from the hair that was ripped out of my head. My eyes were swollen shut from the impact of that man's fist, and my body was so thin it looked as though my bones would rip through my flesh, because eating was a privilege that I had not earned that day. And then we pulled up to a motel. I was told that this was my new home. I remember feeling almost a sigh of relief, thinking that surely in a crowded place like this, someone would see. Someone would help. To paint the scene for you, my pimp had 4 to 8 girls under his control at any given time, while he orchestrated lonely men to come and purchase us for their own sexual deviances. There was no act that we could say no to, and there were no days that we were allowed to have off. With my pimp being openly disrespectful and egregiously violent, surely the hotel would notice. With 40 cars or more coming in and out of the parking lot at all hours, surely the hotel would notice. With girls walking around in their underwear, never alone, never speaking unless be given permission, surely the hotel would notice. And then one day I was hit. Right in the hotel lobby, in front of the man behind the front desk. And in that moment, I knew that someone noticed. But instead of calling the police or doing something to assist me, he looked up at the pimp who had me under his control and said, "Not here, bro." Noticing and acting are 2 very different things. I know that hotel noticed. When I first pulled up to that hotel, it gave me hope, but it did not follow through. The truth is, my trafficker was not just the man who beat me. He was not my only abuser. The Johns who raped me were not my only rapist. My traffickers weren't just the men who controlled me, they were the people who allowed it to happen. My trafficker was the man in the hotel lobby who watched me be abused and did nothing. My trafficker was the maid who emptied trash cans filled with used condoms and cleaned blood-stained sheets and stayed silent. My traffickers were the hotel managers and owners who saw bruised and terrified girls day after day who watched hundreds of men come and go, who witnessed us trying to run away in the parking lot only to be dragged back by our hair screaming, and still they did nothing. My trafficker was the hotel itself. I made it out alive, but the truth is, I had friends who didn't. One of my friends died in critical condition at the hospital after being beaten by our pimp. Her head was smashed against the toilet in a hotel room, which caused the toilet to explode and our room to flood, and still the hotel did nothing. Another friend died under a bridge, hiding from her pimp. There are moms without daughters, fathers who have lost their children, while these people in hotels continue to make money. If the hotel had spoken up, those friends of mine might still be here today. That hotel was complicit, and they were responsible. You see, I was trafficked before it became a hot topic.
Ms. Roper, if you'll try to wind up for me, we're
Yeah.
over time here.
A lot of girls didn't have options back then, and I remember looking up how to get out of the life when I was given my phone for a brief second and finding nothing. We've come a long way since then, and I look up to our governor and first lady because they have been champions for survivors. I have been so grateful for them. But you see, these lawsuits are about so much more than financial independence. Finances matter, but survivors of trafficking are among the highest risks of people living in poverty. More than that, these lawsuits are about justice. Less than 1% of traffickers are ever brought to justice. These give women like me the ability to have a courtroom full of people say that you are valued. Your situation is validated. We see you, and what happened was wrong. Please, what I ask, and I ask just short of begging you, to make a full exception for survivors of trafficking. This means more than money. It means justice. We've come such a long way, and instead of taking a step backwards, let's take another step forwards and protect our daughters. Thank you.
Thank you. Any questions for this witness after a very moving testimony? I don't see any. Thank you very much. All right, Jeff Shaw. Good afternoon. Make sure you pull the mic in or bend down or whatever you need to get close to it. The floor is yours.
All right, my name is Jeff Shaw. I have made the mistake of following Michael enough times that I should not have done it again, as she just reminded me. But I want to contextualize. So I'm a proud Georgian, UGA law grad, Berry College in Rome before that. And I did civil litigation for 6 years in Atlanta before having my heart broken for what Michael just described and starting a nonprofit in 2011 to provide crisis intervention and emergency stabilization for victims of trafficking. And the reason I wanted to address this bill is because in the 14 years that I've been in this work, access to justice has been one of the hardest things to come by. As Michael said, we've made a lot of progress, and I appreciate the comments of, I'm sorry, I don't remember your name, but the therapist who talked about so many of the things that have to be overcome for these survivors of trauma. And I'll also echo Michael and say Georgia has done phenomenal work. When I started in 2011, we were still arresting children and charging them with prostitution, even though we had statutory rape laws, which made no sense, right? But we have come a long way. Every single year, we're down here at the Capitol. So many of you on this committee and in the House have been champions of our cause. And I am not speaking wholesale against the bill, but I want to speak to the exception as it's currently written, and it's written in Section 6, so that's why I wanted to speak today. So in Section 51-3-53 in Part B, it says that nothing in this article shall be construed to limit any cause of action brought pursuant to
And
51.
if I can interrupt you, for
Yes,
members
sir.
of the committee, I believe you're referring to lines 258 and 259.
Thank you.
Go ahead, I'm sorry.
No, that's great. And so that's the civil cause of action for trafficking. And it says relating to a violation of 16.546, and that's the criminal offense. So a couple of things that I think, as written, I think we can make it clearer and stronger. I'm just going to highlight a couple things that I think could be flaws. It only applies to this section. So it only applies to section 6. If you look back in section 1, where there's an amendment in 910, and I'm sorry, I'm going to go fast because I want to stay within my time. But the impact of attorneys not being able to advocate for non-economic damages during the trial, and that's been referenced as well. Again, it's one more hurdle for trafficking survivors that probably haven't kept, they probably don't have lost wages, they don't have receipts, they don't have medical bills. Moving on to section 2, 91112, defendants can delay their answer by filing motions and dragging out the litigation even longer, which again was referenced earlier, that for trafficking survivors that are trying to make it day by day, drawing out litigation can be fatal to their claims, and they can lose hope in the process. The next section in 3, 91141 about dismissal and refiling, it is not uncommon that trafficking survivors would want to dismiss and refile their claims as they're navigating the fear of the process and also threats from their traffickers, or a lot of familial trafficking. They may be getting threats and coercion from their own families. And if they lose the case on the adjudication of the merits due to dismissal, that again could be another challenge for survivors. And then in section 7, I know there will be a whole discussion around collateral source doctrine. That's again just another potential ding to survivors getting a full recovery. And then in section 8, where it talks about bifurcation, which again was referenced earlier, I represented a 12-year-old victim of sex trafficking who is trafficked in Cobb County in a RICO case against her trafficker and a buyer. And what she went through in her deposition was one of the most brutal things that I've ever witnessed. We left with her sobbing multiple times, and she wanted to quit her case after that. Now, she had the resilience to come back around and get a successful resolution, but for her to have been deposed, come back and testify to liability, and then come back and testify to damages, as we heard earlier, is just very re-traumatizing. So I'll close my time with this. I had lunch unplanned with a survivor that we served in 2011, the first person we ever helped exit trafficking, and she had a successful case against Red Roof Inn, and it was a lot of what you just heard Michael describe. And she told me on Saturday, in 14 years of being out of trafficking, that successful litigation was the most meaningful experience that she's had, more than the services she's received or anything else. And so I want to encourage that we just pass the right language here that exempts trafficking survivors from all of SB 68 so we can continue to move forward and not take a step backward. Thank you.
Thank you for your testimony. Any questions of this witness by members of the committee? I don't see any questions. Thank you very much for coming today. Genesis Wilson.
Hi everyone, my name is Genesis Wilson. April 1st, 2021, present was Judge Brown, my mother, my dad, my big brother, Miss Michelle, Mary, and my legal team. 4 years ago, I didn't see any good in the situation that I had survived, but today I stand before you thankful. And if I could go back in time, I wouldn't change anything. I am who I am today because of what happened to me. I've developed a heart so big for women who've been through sexual assault or sex trafficking. And I hope that one day to share my story to help save another woman who is stuck in this terrible situation, and to give her hope to remain strong and to hold her head high. She and I are so much more than the pain we had to endure for a man's greed, and I know for a fact that God didn't make me go through that for no reason. I'm actually thankful because I'm now a very strong woman who hopefully one day will make a difference in this world. I will always be stronger for what I went through, and I will always be more than the little girl who was saved in the back seat of a car on July 23rd, 2017. All I ask is for you to reflect on the amount of damage and trauma that you caused me and learn from it and never do it again. Ladies and gentlemen, I stand before you almost 4 years later, exactly, living in complete answered prayers. I read that statement as a young, newly traumatized 21-year-old. I was homeless and I had a substance abuse problem. I was emotionally destructive, but I still had dreams and aspirations for myself. And due to the trauma that I experienced from being sex trafficked, I was unable to attend college that summer of 2017 because I had to relocate to another state for my safety. Unfortunately, I was never able to get back onto the path that I intended after high school, but today I stand before you as a youth project coordinator for a nonprofit organization that offers pathways to wellness for women overcoming sex trafficking, prostitution, and addiction called Divas Who Win Freedom Center. I lead 15 young teenage girls, offering them my experience and my guidance to help prevent the youth in my community from ending up in the same situation. If I would have never received a settlement for my pain and suffering, I don't think that I would be able to cause the same impact in my community how I do. I wasn't able to afford health care and therapy prior, and therapy has really helped me process my emotions and be able to advocate for other survivors. My settlement has given me a purpose, motivated me to speak out about my trauma because I'm no longer stuck in it. I believe that I would have been a lost soul due to the abuse of my trafficker and the negligence from the establishment where the trafficking took place. I want to be able to see the same justice for my brothers and sisters who are survivors of sex trafficking. And I ask that there be an exception in the tort reform bill for sex trafficking survivors so we don't lose again and are able to receive our justice. Thank you.
Thank you, ma'am. I don't see any questions for you. Thank you for your testimony. Is it Shonda Santana?
All right. Good afternoon. My name is Shonda Santana. Honorable members of the General Assembly. The day was Sunday, July 23rd, 2017, 9:33 a.m. I received a call from an on-duty FBI agent notifying me that my 17-year-old daughter had been extracted from a family of traffickers. I come before you today carrying the weight of lived experience, the weight of a mother who has fought for her child's freedom, the weight of a survivor turned advocate, and the weight of a woman in long-term recovery who knows that accountability is the foundation of justice. I represent Divas Who Win Freedom Center, founded in 2018 in Athens, Georgia, after my 17-year-old daughter had been exploited at numerous hotels and motels throughout the metropolitan area. At Divas Who Win Freedom Center, we walk alongside survivors of sex trafficking, addiction, and exploitation every single day. But today, I am not just speaking on behalf of an organization. I am speaking as a mother whose child was trafficked. I am speaking for every parent who has had to sit in the quiet agony of knowing that their baby was being sold while businesses turned a blind eye. Now, let's be clear. Motels are not innocent bystanders in this crisis. They are not helpless victims of crime. They are active participants, profiteers of pain, who have allowed traffickers to run their operations freely, unchecked, and in some cases with full knowledge and even collaboration. If we pass this bill without an exception to hold motels accountable, we are giving them a pass to continue cashing in on our children's suffering. We are telling survivors that their pain is not worthy of justice. We are telling traffickers that they will always find safe haven in the same dingy rooms behind the same front desk and have seen it all and done nothing. This isn't speculation, this is fact. We have seen the same motels over and over again serve as breeding grounds for abuse, places where young girls are lined up outside rooms like merchandise, where front desk workers accept bribes to keep their mouths shut, where security guards signal to traffickers when law enforcement is near, and still they continue to operate, raking in profit while survivors fight to reclaim their lives. Tort reform, as written, only protects those in power. It takes away one of the few tools survivors have to demand accountability. We cannot allow that. Civil lawsuits have already shut down 5 of the worst hotels in Atlanta for trafficking, not because the government stepped in, but because survivors and advocates fought to hold them accountable. Without that power, these businesses will continue to thrive while our children suffer in silence. So I ask you, who will we protect? Because if it's not the survivors, if it's not the parents fighting for their children, then this system is failing all over again. So I stand before you to invite an exception. If a business has been complicit in trafficking, if they have ignored the signs, facilitated the crimes, or profited from the pain, then they must be held accountable. Anything less is an endorsement of trafficking itself. I'm here as a mother, as a woman in recovery, as an advocate who refuses to be silent while this system continues to fail the very people it claims to protect. The choice is yours. Will you stand with survivors, or will you stand with the businesses that have built their wealth on the suffering? Please add the exception. Hold motels accountable. Do what is just. Thank you.
Thank you. Do we have any questions of this witness? I don't see any questions. Thank you very much. John, is it? Tanj. Thank you, sir.
I think you guys have seen that already, but the exception language that we're talking about is in the footnote on that page. I'm sorry, can you guys hear me? Thank you all for your time and for being here today. My name is Jonathan Tanj. In 2015, when I was in law school at the University of Georgia, I had an idea that I would represent survivors of sex trafficking and sue hotels. At that time, nobody did that. There was one case in the country, and nobody else had ever done that. And that weighed heavily on me. And so since then, till today, that's all I ever wanted to do. And that's, since 2019, that's all I've done. I don't do other kind of cases. I don't represent anybody else but sex trafficking survivors in civil cases. In 2019, we filed the first case in Georgia history in federal court. In 2020, we filed the first case in Georgia state court. Also, that went up to the Court of Appeals. And I've probably been involved in 80% of the cases in the state of Georgia since then. Last year, I taught the first class in human trafficking litigation at the University of Georgia Law School. I taught a bunch of kids how to interpret statutes and read negligence and nuisance laws to hold businesses accountable. And at the time, I didn't realize that would be potentially useless information 6 months later. Georgia has led the nation in passing laws in the last decade. They've done a lot of things that have helped a lot of my clients personally, changing names privately, expungement laws. Those things make a big difference in my clients' lives. But the bill is currently written. There will never be another survivor file a case in Georgia courts. It would be malpractice to do that. And there's a couple of reasons, but here's the big ones. Right now, survivors have 3 main claims. The best claim is a negligence claim. It's the oldest one that's been around. We know how it works. It gets litigated all the time. It has a low standard. It has a low burden of proof. It's a reasonableness standard. It should have known a lot of the time. That's going to be gone, and that's every kind of negligence. Like negligent supervision is gone under this bill. Negligent security is gone. There is no type of negligence claim that will survive in the case of a trafficking victim, because there's always a trafficker who's a third party who the allegation would be that the hotel should have kept them safe. The second claim is a nuisance claim, and these haven't been used in probably 80 years to sue lewd houses or houses of ill repute, but that's one of the oldest negligence claims in Georgia. We've always said that. In 1910, Georgia said that private citizens that are hurt by a nuisance property can sue that property, and the important thing about a nuisance claim is it's the only claim that a survivor has that can shut down a property. You can get damages for negligence, but you can abate a nuisance, and a judge can say, this company can no longer run this hotel, and you have to leave. And this is why, I mean, these are not like some of these other businesses I've heard talked about. This is not a Home Depot, right? I've had almost 30 clients who are all trafficked at the same 2 hotels in Atlanta. And so you can't tell me that's a coincidence. That's not, a bad thing happened on one day at a property. That's a repeated pattern over more than a decade that has affected a generation of girls in Atlanta. And that's why the Gwinnett Chamber of Commerce supports this exception, because it's good for business. Normal businesses don't want to be beside these places either. Nobody wants to be beside a hotel that sells kids for sex. If there's anybody in the room that thinks it's a good idea to shield hotels from liability who allow kids to be sold for sex, let's raise a hand. Right, because people don't want to do that. These are not all businesses are good actors, and nuisance appears once in the statute, and because of that, 115 years of nuisance law is gone out the window, and we don't have a claim that could shut down a bad property. Finally, so what you're left with is one claim, right? And you've heard about the bundle of sticks, like bundle of sticks is strong, right? But one stick you can break. So now you got one stick left if you're a trafficking survivor, and it's this civil cause of action that has never gone up to the Court of Appeals. Nobody knows what it means, and it's a much higher standard than either negligence or nuisance. And it's modeled after the federal law that I've been litigating without any guidance also for the last 6 years. And I can tell you exactly what defendants will say. Hotels will first say that this law means you can only sue the trafficker, because that's what they did 6 years ago in federal court. If they lose that, they're going to say that the hotel has to participate in a venture. And do you know what a venture means? It means that you have to be in a venture that is illegal with this sex trafficker. So hotel and the trafficker have to be in a conspiracy together, and that's what a venture means. And it's very similar language in federal court. And about half the district court judges in Atlanta think that it's kind of a negligence standard, and about the other half of federal judges in Atlanta think that it's a criminal standard. And so anyone that tells you that they know what a court is going to do with this civil cause of action is making it up, because it's never been litigated, it's never been seen. I've seen a lot of the arguments, and the standard is going to be high, and they're going to say that the hotel has to be criminal. And I'll be clear, a lot of these hotels are criminal, right? And we say that in our cases, but a jury should be able to say, this hotel was negligent, this is a nuisance in our community, and we want it gone. And in addition to some other provisions, if all that's left is that civil cause of action, trafficking survivors are going to use the law in federal court because it's better for them, because there are more protections, there's a rape shield law, there's different things, and no one will ever use this law that we spent all this time in 21 trying to get passed, and that would be a tragedy.
So 51-156, that's the civil cause of action.
Yes, sir.
Correct. All right. And you're aware there is an exception in the bill. I think it's been mentioned before. I don't recall if you referred to it. There is an exception that I think got added in the Senate, and I think the line 258, 259. But I think there was some testimony earlier that exception is not viewed to be as comforting as it might otherwise appear. Could you please comment on
Sure.
I'm assuming you're in that category, and would you tell me why you don't feel like that's sufficient?
Yes, sir, and I appreciate that attempt, actually, and I would love to talk to you more about it if you would like. That's what I'm saying. Like, with that exception, with the second version of the bill that has that exception in there, it protects that civil cause of action, that we don't know what it is, and that standards are that's the way the words are written, the standards are much higher than negligence, much higher than nuisance. And so the negligent security bill kills negligent claims and it kills nuisance claims, and that saving provision there only protects that civil cause of action. It does not protect a negligence claim or a nuisance claim.
So how do you view the bill impacts a negligence claim? Do you feel like it falls within the concept of
I don't think anybody will ever file a negligent security claim after this passes. On page 8 of the bill, if you look from line 172 to 190, just while I was sitting there, I've counted 13 different knowledge requirements on that page of the bill, including that the owner of the property has to, quote, consciously understand that a third person is likely to imminently engage in wrongful conduct. I don't know, I've never heard of any standard in the law that required conscious understanding. And so as far as I know, the only way you could prove that is if, in our case, as a hotel owner said, yes, absolutely, I knew that this individual was about to traffic this person in this room, and he told me so. And you know what? I'll admit it also on the stand. And I've deposed probably more hotel owners than most people in this room, and not one has ever admitted that they've ever seen anything that looked like prostitution. much less sex trafficking or any other kind of crime. So, I mean, like, requiring, I mean, consciously understand is that's inside somebody's head. And, I mean, they're just going to lie about it because that's what they do in our cases.
And tell me, where is that language
That is on line 174.
in the definitions?
Yes, sir.
Okay, yeah. I see what you're-
I counted 10 knowledge requirements in the definition of subsection 3 between 172 and 179.
Okay. Right, and then the nuisance, I think you said there's language in the statute that it causes you concern to believe that a nuisance claim would also be barred by the,
So on line 164, the prior page, negligent security is defined as a claim against an owner or occupier or security contractor that subsection A sounds in tort or nuisance, including but not limited to any claim under Article 1 of this chapter. If you take it, that's the only time the statute mentions the word nuisance, but I mean, that sweeps in the whole, that says that this negligent security claim replaces nuisance if the nuisance you're suing about is based on a failure to keep a party safe from a third person, which is what every trafficking claim is.
okay. All right, thank you. I think you've got
Yes,
enough.
sir.
Thank you, Mr. Chairman. Thank you so much for being here today. I think we got it, but some of us on the committee are lawyers and some of us are not. The exception that was written into the Senate bill, even for a sex trafficking victim, does not protect a nuisance claim for them, does not protect a negligent security claim for them. Is that right?
Correct.
And it only protects the statute 2151,
51.
156. I got too many papers in front of me. Is that the right one?
Yes, it protects the independent cause of action that was passed in 2021 for to provide a civil claim for victims of sex trafficking.
And your concern with that is it doesn't have the body of law that negligence has, and you, as probably the most experienced in this state, you wouldn't bring a claim under Georgia law if SB 68 passed.
Absolutely not. No, but I mean, it would literally be malpractice when you compare the claim to what's in federal court and the protections that you have in federal court versus what it is in Georgia court. And that's just not what Georgia's ever been about. I mean, we've never said, you know, we're going to outsource protection of victims in our state to the federal government. I don't think that's what we've ever tried to do.
One last question, if I might, Mr. Chairman. Again, thank you for being here. And these concerns about not protecting nuisance and negligent security claims for sex trafficking victims goes beyond the concern we heard earlier that the other sections wouldn't be accepted for them too. Am I correct? Like the unlimited stay of discovery, the bifurcation, all of that is in addition to these concerns.
Yeah, those are additional problems, and I honestly was just trying to keep it within time, frankly, and addressing the biggest issues. But yeah.
Thank you.
Thank you.
Thank you. Did you have a question? Hold on, if I get you to come back one more minute. Let's see. Number 2. Chairman Newton.
Thank you, Mr. Chairman. Just in the section there, 258 and 259, nothing in this article shall be construed to limit any cause of action brought pursuant. That's the federal code, the 51-1-56.
No, that's the state code.
That means, okay. And then 16-5-46 is our sex trafficking.
That's the criminal statute, yes. And so 16 is what makes sex trafficking a crime. And then 51
is civil.
It says if you are a victim of this crime, you have a civil cause of action against anyone who participated in a venture that they knew or should have known involved a violation of the criminal statute.
Is there a way to word this where sex trafficking was able to use nothing in this article, Article 5 under Section 6? Is there a way to word those two lines that would not cause the problem that you're so well describing?
That would keep the nuisance and negligence claims?
Right.
Yeah, it's footnote 1 in that letter I handed you guys.
Okay.
That the Gwinnett Chamber endorsed.
All right. Thank you. Thank you very much.
Yes, sir. Thank you, guys.
Thank you for your testimony. And by the way, ladies and gentlemen, we've encountered this. Those of you who've been in the room before know it. It sounds like some people are dribbling and passing a basketball back in that corner, but they really aren't. There's apparently a problem with the speakers. They keep at least popping and arcing up here. So I apologize for that. I know it's a bit distracting, but that's the sound system we have. So my apologies. Mike Moore, is it Moran? Moran. Mr. Brown, when you're ready, sir.
Thank you, Mr. Chairman. All right, as I said or indicated, my name is Mike Moran. I'm born and raised in Jessup, but been living in Atlanta for the past almost 30 years, practicing law here for 27 years, and a good bit of my practice over those years has been negligent security cases. I could not even begin to count how many very serious negligent security cases that we've done over the years. And after this bill, the substituted bill was passed out of the Senate. I read it very closely, obviously, and in thinking over the 27 years that I've been practicing, I can't think of a single negligent security case that we have had that would survive this bill. I can't think of a single real-world case that would survive this bill. This is a very, very harsh bill. There are members of this committee who I met with last year to talk about a bill that was proposed last year, and that bill, in a very transparent way, would have eliminated negligent security cases. And the people that I met with last year were against that. They didn't want to see all cases eliminated. You know, that there's a need for tort reform, perhaps, and there's a meaning or a smart way to do it, but not to eliminate all of the claims. This bill does the same thing, but just in a much more complicated way. It's very complicated how it does it, but you get to the same exact place. I'll try to break down the bill in a succinct way. There are only a couple of paths to prove a claim under this bill, and if you look at lines 204 is where it starts through 233, it tells you how you prove one. And it says an owner or occupier on line 204 shall be liable for negligent security arising from any injury sustained by any person upon the premises of the owner or occupier as an invitee if the plaintiff proves that, and then line 207 and 208, the wrongful conduct was reasonably foreseeable because the owner or occupier, and then you have several more lines, and that provides 5 ways to prove it. One is this particularized warning, and then 4 other ways through prior substantially similar crime. Now, as to the particularized warning, the speaker before me, Mr. Tonge, touched on that. That's lines 173 through 180. And the particularized warning of imminent wrongful conduct by a third person means information actually known to an owner-occupier and deemed credible by the owner. So again, as Mr. Tonge said, the owner would have to admit that he or she believed that the particularized warning was credible. If the owner says, I didn't believe it, it doesn't matter how overwhelming the evidence is, because the standard is what that owner believes in his or her mind, which can only be known by what they say. So you would get summary judgment on that claim in every single case against the plaintiff once the owner said, well, I just didn't believe it. I didn't think it was credible. The particularized warning would also have to be, this is line 176, that the third person is likely to imminently engage in wrongful conduct. Well, imminent means, soon. So if you got a warning that it was the next day or the next week, that wouldn't matter. Line 178 or 177 says the warning would have to be, quote, specific as to the identity of the third person. Well, identity presumably would mean the person's name. You would, if you're giving a warning about this person, you would have to identify them. So these are the elements of particularized warning could just never be met. So there's no real world way to ever prove a claim under that way to get to it. All the rest of them from lines 210 through 221 are about prior substantially similar crime. And the prior substantially similar crime would all have to be as a result of a physical condition on the property. So you would have to prove that each prior similar crime was a result of a physical condition on the property. So it wouldn't matter how many robberies or murders or rapes or whatever it was that had occurred on a property. If it wasn't because of a physical defect, that wouldn't be considered substantially similar. So you're effectively immunizing malls, gas stations, people that don't have, businesses that don't have fences and gates. You also, and if you turn over to lines 224 through 228, that tells you that after you if you can prove that there was this, well, I actually skipped something too. On line 210, I think we should point out that this raises the burden of proof. And so if what we're trying to get at here is to make sure that only really serious cases where innocent people have been harmed as a result of clear negligence of the property owner, increasing the burden of proof is a very effective way to do it. And line 210 raises the standard to clear and convincing evidence. That's a very effective way to weed out frivolous claims. So I think it bears just emphasizing that and people not forgetting that. But over in lines 224 through 228, you would also have to prove that the litigated crime, meaning the one that the lawsuit was filed about, was a result of the third person exploiting a specific physical condition, which is lines 225. So the litigated crime would have to be as a result of a physical condition. So if you had a case against a gas station or a mall, it's just not going to survive this statute because they're not fenced, or there's not a lock that was negligently maintained that somebody entered an apartment complex through. So we did a case against a local mall a couple of years ago where there were over, and this is a prominent mall, where there were over 32 weapons crimes in just 12 months before our client was abducted and raped from that mall. And some of those were murder and several armed robberies, several women who were robbed at gunpoint. It wouldn't matter under this statute because there's not a physical problem that led to that. These are criminals that are just walking around on the property without being checked by security guards. So you're completely disincentivizing the use of security guards as well. Also, it also requires that let me get the line number. Line 227, so the litigated crime you'd have to show that the physical condition that was exploited created a reasonably foreseeable risk of wrongful conduct on the premises that was substantially greater than the general risk of wrongful conduct in the vicinity of the premises. And if we want to go back to first principles on tort law, one of the reasons for having tort law is that we decided years ago you want to incentivize property owners and people to behave in a safe way. It's not just about compensating injured victims, it's about incentives. And here you're creating a horrible incentive. You're creating an incentive of a race to the bottom, because if every property owner in the area does nothing, you could never prove that anyone, it was substantially greater risk than any other property. So that's a horrible incentive. The last thing I'll mention very briefly is the provision about security guards. And all I'll say, they must have very good lobbyists, because I don't know how you could ever sue a security company under this bill, because it ties their liability has to be identical to the liability of the property owner.
And you're talking about the final section in that?
Correct. Lines
331 to 342?
That's correct. Okay. And it says that their liability would have to be identical to that of a property owner. Well, as I've mentioned several times, the property owner's liability is tied to a physical condition, but security guards aren't responsible for physical conditions. So there's no, and they would no longer be liable for if they completely breached their contract and a third party was injured. So if the guard is drunk in his car asleep or doesn't show up, or if the guard's participating in the crime, you would not have a cause of action against a security company under this bill. So I understand the governor's concerns and what other members have had concerns about tort reform, and we can all work together to get meaningful, fair tort reform. There's always balance to find, and we can certainly work together and fix this legislation or edit it, and there's certainly balance in the middle that we can meet, but this bill does not do it.
Well, thank you. I think you have a question from Representative Williams.
Thank you, Mr. Chairman. Thank you, sir. Can you think of an instance under the sections, and the section that we're talking about and the lines that you've explained, can you think of an instance where someone would be guilty of gross negligence? just give me an example.
You mean just like in a negligent security case where a business would be culpable for gross negligence?
Yeah. Uh-huh.
I mean, sure, you could come up with a fact pattern.
Under,
Like a specific knowledge sort of thing where they know exactly what the criminal is doing and maybe is in a conspiracy for the crime that's going to be committed. I mean, that would be pretty gross negligence.
one follow-up, please. You've said that how you've interpreted this, you almost said, I understood you to say that it'd be just almost impossible to prove negligence. That's why I'm asking, is there an instance where it can be, or you think that this bill will eliminate the possibility of proving gross negligence?
Well, it would eliminate the possibility. There's just no real world case where you're going to meet all the elements required under this statute. I can't think of one. I mean, it was that particularized warning we talked about, that's just never going to work. So then you're stuck with prior substantially similar crime, and it all having to be limited to the physical condition, and then you have to prove it's substantially greater risk than the neighborhood. I don't even know how you would prove that, how you could ever meet that element. So yes, I think you could never satisfy every element under this statute.
Thank you. Got one more question here from Chair Lady Miller.
Thank you, Mr. Chairman. Just two questions. The first question, which I'm going to piggyback a little bit on my colleague, Representative Williams' question, because there are some of us who are not lawyers and who don't understand kind of how this cause of action works. What kind of prior facts, I guess, have in your practice demonstrated a foreseeable risk? In other words, we're not dealing with apartment complexes or property owners that just someone comes on their property, then someone commits a crime, and now they're being held responsible for it. What are the kinds of fact patterns, past behavior, substantially similar crimes that you have seen in the cases that you have worked, which really is what the level of knowledge has to rise to hold a property owner accountable?
Yes, primarily prior substantially similar crime. And so usually the places that we're suing in these cases have a long history of prior violent crime that they've turned a blind eye to.
And you're saying that based on the way this is written, that even those cases wouldn't work now?
No, those cases would not work.
Okay. Secondly, can you talk a little bit about some of the crime victims that you have represented? In other words, what kinds of criminal acts have your clients experienced on these properties? We just get this sense that this isn't a real thing and that somehow, this is a made-up practice of law that is just sort of, running rampant in our justice system. Can you talk a little bit about the victims that you represent?
Well, sure. We've represented countless victims of rape and murder and horrible things. People who have been abducted. I didn't touch on this, but this bill 100% immunizes properties from a claim against them for someone being abducted from the property. So if someone is abducted at a convenience store, young girl pumping gas, is abducted and taken somewhere else and raped and murdered, it wouldn't matter if it had happened 1,000 times before. You do not have a claim for that rape and murder. Maybe you have a claim for battery for the abduction itself, but the statute very clearly says you do not have a claim for the abduction. I can't imagine what the policy goal behind that is.
Because it doesn't happen.
Correct.
All right. I believe did you have a question, Representative? I don't think you have any questions. Thank you.
Thank you
very much.
Thank you, Mr. Chairman.
You're ready. Remember, try to keep it to 4 minutes if you would.
Got it. Good afternoon. Thank you, Mr. Chairman. Thank you, committee. I am attorney Chris Stewart. I'm also the first and only African-American voted attorney of the year for the state of Georgia. I was given the Outstanding Georgia Citizen Award by Governor Kemp for fighting for Georgians. So it hurts today to be disagreeing with people that I highly respect. But this bill is wrong, and that's why I'm here. I'm here fighting for Georgians. I'm not here to try and get people to change their vote because I understand politics too well. I've had cases where I've had to be in the White House over 5 times. I know how politics works, and I understand the pressure that many people are under right now to force this through. But I have not lost faith in all of you because I know the people that put you in that position still have faith in you. And I know that this bill is going to destroy lives. And I'm not exaggerating because I don't need to exaggerate. This bill is going to destroy lives. All you've heard from one of the shining examples during the proponents of this case is the racetrack situation. Well, that's my case. I represent the mother of the 1-year-old who was murdered from a shooting at the racetrack. You have heard that it was a place where they ate, where students went, that it was a nice place and that there wasn't crime. What you haven't heard is from the students.
To a once underserved community, and they did so intentionally and specifically 24 hours a day, 7 days a week. The community needed it.
GSU SGA Senator Sarah Forberger says enough.
There's been a push for years to get this racetrack shut down.
Forberger's wish came true Monday. Since the closure of this racetrack gas station,
It has been a lot quieter.
GSU students say they're starting to see a more peaceful Piedmont Avenue.
There has been less activity.
The location closed in February, racetrack noting safety as one of the reasons why. GSU Police Chief Anthony Coleman saying in part, quote, "Crime has significantly dropped after the gas station closed. We would like for a business to move into that space that will be more compatible with underage students, such as food or trails."
There has been quite a bit of violence, I would say, connected to the gas station. Hopefully it turns into something a little bit more.
That's the students of GSU. That's the police chief at GSU. That is the gas station that we closed. And I understand that racetrack is a great business. It is a multi-billion-dollar business in Georgia. They had to move a location that was riddled with crime. That was not a frivolous lawsuit. That is what premises liability does. It saves lives. The other impact that you are going to see, because I've done thousands of these cases, is our off-duty cops are going to be terminated. Allied Security and all of the private companies are going to be terminated immediately because they are not going to keep that overhead at apartments in Georgia. That is a fact. I have sued some of the biggest apartment complex owners in this state. They are all out of town. I get their emails. They joke about the apartments in Georgia. They have nicknames for apartments in Georgia. Little Haiti, Little Iraq, Little Afghanistan, where people are dying. That is who we are protecting with this bill. They will not keep our off-duty cops. So there's going to be a trickle-down effect, not just of the loss of jobs, but the increase in crime. So whatever county you are living in, there will be less security and crime will raise. That is a fact that is going to happen. So I'm here to talk to Georgians. I want this to be on the record for the next elections and the next time that we battle, because this will serve as a message that there was a warning, that you may be able to limit some lawsuits or change things, and we are willing to try and work things out. But crime is going to rise because situations like racetrack. This was racetrack. Are now not going to be able to be touched. And the proof is in the facts. Crime can be stopped with the proper negligent security case. And that is why we're here, and that is why we are hoping and praying that you find it in yourself to step forward and vote no to SB 68, despite the pressure you may be under. Thank you, Chairman.
Thank you. Do we have any questions? Representative Evans?
Thank you, Mr. Chairman. I want to make sure I heard correctly this racetrack case that we've heard so much about. the victim of the crime there was 1 year old?
She had a 1-year-old daughter.
1-year-old daughter. Could you tell us, you mentioned that off-duty security would go away and we would see these places stop, and I agree with you. Could you explain a little bit to the committee members why you believe that?
Yes. In a lot of the lawsuits, what happens is the apartment complex does not have security. We sue them, we fight, they add security. You can look at Campbellton Road, the apartment complex is there. They added allied security after our lawsuit. A man had been shot at the mailbox multiple times for like the 6th time. They add security because they fear lawsuits. When we can't do that anymore, do you think that a company is willingly going to spend on average it's $200,000 to $300,000 a year? Do you really trust these out-of-state companies to do that? I don't. I trust Georgians.
Thank you. Representative Williams.
Listening, thank you, sir. As you leave, would it be safe to say that you're probably not going to get the Citizen of the Year award again?
What's that?
Is it safe to say you're not going to get the Citizen of the Year award again?
Probably not. I mean,
I don't think so.
you know, the great thing is I'm not Republican or Democrat. I go with who's got the best idea. I agree with Trump when he said that in Florida this was the biggest insurance scam in history when they tried to pass the same thing. I support who's got the best idea. Trump had it then. I'm sure he would have it in Georgia. I still respect Governor Kemp. I just don't respect this bill.
Thank you, sir. Appreciate your testimony. All right, I believe this is a crime victim. Just use their initials, BJS. And I'll try to signal to you as you get close to the end of your time. So if I do like that, I'm not saying peace. I'm telling you, you got 2 minutes to go.
Understood. Thank you. Am I close enough? All right. All right. Well, good afternoon, Chairman and respected committee members, and to all the survivors that are speaking today. That is helping me draw strength in order to talk. Today I speak on behalf of my family. I'm the proud mother of 2 amazing boys. But today I want to specifically speak about this child. This is my son who at 7 years old was sexually abused numerous times by another child at a summer day camp. The impact of our son and family have been devastating. We will be dealing with this traumatic impact for the rest of our lives. We filed a civil premise liability lawsuit not only to obtain accountability and justice for our son, but under the Senate Bill 68, families like ours would be denied that right. SB 68 would have barred our claim entirely because our child was assaulted due to multiple failures by the camp in following and enforcing their own abuse prevention policies rather than because of some physical condition at the camp. We would have been completely stripped of our ability to seek justice and long-term treatment for our son. And we would have had no other way to hold those negligent parties responsible for their failures to keep him safe. SB 68 is bad for children and families. Georgians want better, and Georgians deserve better than SB 68. Thank you.
Thank you. Any questions of this nice lady? I don't see any questions. Thank you very much. E.G.
Good afternoon. Put on my glasses so I can see what I wrote here. I myself am very concerned about SB 68. I am a survivor myself of sexual assault and kidnapping. I do not relish going back to talk about this, but because of my concern, I have to. I was shopping at a major grocery store chain in Athens, Georgia. As I left that store and I walked out to my car, I was ambushed at knife point by 3 men. I was taken against my will. I was fighting. I was screaming. I was beaten. I was choked. I was taken to a dirt road in Morgan County. I was taken out of the car. I had my clothes removed, and I was gang raped on the hood and the trunk of my car. I thought for sure that dirt road would be my final resting place. For some reason, these offenders took me what ended up to being St. Petersburg, Florida. Along the way, I was raped again. I never got my clothes back. I was tied up. I was humiliated. It was July. It was very hot. I was not given any water. When I could urinate, I had to do it squatting in front of them. I was threatened continually. And as we got there, these attackers seemed to come down from the drugs that they had been smoking and taking in that parking lot. They seemed to sober up. I begged, I pleaded, I bargained for my life. I convinced them that what I had looked like was just a result of a mugging and I didn't know who did it. For some reason, they did let me go. I made it to a phone and I called 911. Police came. I was taken to a rape crisis center. An investigation began and my attackers were found and they were arrested. They were then prosecuted. I sat and testified through 2 criminal trials, and yes, that is reliving it twice. I then filed a lawsuit, a civil lawsuit in Athens, Clarke County against this grocery store chain where I was their customer and they had failed to keep the premises safe under Georgia Law Code Section 51-3-1. My case went to trial before a jury in Athens, and during this trial, my attorneys presented the evidence, including a history of prior crimes, specifically one victim's warning about the need for security after his attack in the same parking lot, and the defendant during this trial finally agreed to my settlement demand. Through my civil lawsuit, I learned many things. My attackers had been loitering. They were in that parking lot, getting high, and looking and waiting for a customer to attack and kidnap. Other customers had been victimized and attacked in that same parking lot on different occasions prior to my assault. Sorry. The defendant of the civil lawsuit had indeed been warned by a previous assault victim in that parking lot, and it needed security, and as the victim bluntly stated, before someone gets killed. This defendant knew about and investigated this prior attack and refused to provide any security in the lot after being warned by that very attacked victim. There was no problem with the physical condition of that parking lot. That the defendant provided no parking lot security to prevent my attack, nor was any security provided to stop the loitering, the taking of the drugs, that lying in wait for me, I became a victim. I have fought hard for my body and my mental state all of these years. These crimes and my traumatic experience are never far away from my thoughts. What happened to me shattered my life and can never be undone. It has been a long, tough road, and I will never fully heal. But having my rights as a victim has made me the woman that can stand here today and talk about this. My rights as a victim to pursue these has given me strength and power to continue to become an educator, a partner, a mother, and most of all, a survivor. would have never come forward under this new bill. I have learned that this bill will take away rights. It will be harder to hold negligent property owners accountable. It is bad for store customers that are very unsuspecting. I can tell you that sexual assault survivors deserve better than SB 68, and all of us in Georgia deserve better. I'm asking for this to be amended so that it is fair to victims.
Thank you. All right. Thank you. Do we have any questions of this witness? I don't see any questions. Thank you very much. I believe the next witness is YC. All right, ma'am, when you're ready.
In 2017, I was working out in the fitness center of my apartment complex. After done working out, I walked to the door to go to my unit. As soon as I opened the door, a man pushed me into the small space by the vending machine. I tried to fight back, but he grabbed my wrist. I yelled no and please let me go repeatedly, but he didn't let me go. He tried to reach my pants and my upper body. He leaned his body over me so I couldn't move. Then he started masturbating on my sweater. After he was done masturbating, he ran away. That was the night of March 4th, 2017. And what happened that night changed the rest of my life. A man who attacked me didn't live at the complex, but he was able to come onto the property because there was no security. The owner of the complex and management, they choose to have no security, even though there had been ongoing dangerous crime at the property. In the 2 years before my attack, this property had crimes such as armed masturbating, peeping Tom, armed robbery, sexual assault, home invasions, apartment break-ins, suspicious person. The list goes on. Incredibly, the owner of the complex, they violated their own policies and procedure, but by not telling me about the criminal activities. They didn't conduct security assessment or implement security. There was not enough lighting, no security cameras, or secure gates. All they cared about was getting more tenants to move on to the property. That was the reason why I filed civil lawsuit against the owner of the complex for failing to keep the premises safe as required under Georgia law. Fortunately, my case went to trial in 2022, and the jury returned a verdict in my favor. Gratefully, during the trial, 3 prior female victims at the complex testified about notifying the apartment management about suspicious activities. One described having to spread broken glasses on her patio so she could hear when the suspicious person came back in the middle of the night and called 911. That was after the apartment management refused to do anything in response to her reports of a suspicious person attempting to break in. It took us 5 years to go to trial. It was a hard 5 years. I was not able to find a high-paying job as I did not look or sound confident at the job interview. I also had to leave one job because they didn't provide a secure workplace. And I had one incident with them that remind me of the night of March 2017.
Ma'am, if you'll conclude your testimony for me, we're at 4 minutes.
My marriage was not going well either. My husband wanted to divorce me as I was not able to have an intimate relationship with him. Not only that, we argued endlessly. We basically hit our bottom so hard. We couldn't keep up our mortgage payments, and we couldn't see any hope. We realized that we could no longer live in Georgia anymore, so we decided to move back to California and start a new life. The night of March 2017 shattered my life, and the mental trauma that I have is something that I have to deal with it the rest of my life. The monetary verdicts that I received in 2022 cannot undo what happened in March 2017, but it definitely gives me a peace of mind as I don't have to worry about whether I will be able to make a payment or not. And also, I no longer hesitate to seek for medical or psychological assistance if I have to look for one. Today I'm here because SB 68 would have barred my claim, and not only that, it could bar any claims that victims like me deserve to receive. Furthermore, this will allow the owner and the management of the apartment complex to avoid responsibility for their negligence and accountability for what should have never happened to me. I truly think that sexual assault survivors like me deserve better than SB 68. And please do not pass SB 68. Thank you for listening to my testimony.
Thank you for your testimony. I don't see any questions. And the other victim we have is BW. And the hour's getting a little late. If you'll really try just to keep your testimony to 4 minutes for me. I know these are very compelling stories, but if you'll try to be brief, we'd appreciate it. All right, the floor is yours. Thank you.
Good afternoon. My name is Brandon Washington, and I am a survivor. In April of 2020, I was involuntarily placed in a behavioral health facility in Atlanta because of my mental health challenges that I have had since I was a young child. I was 16 years old at the time. While at the facility, another adolescent who was assigned to share a room with me sexually assaulted me. I was a scared kid away from my parents, alone in a mental health facility, and I did not know what to do and had nowhere to turn. Some of the darkest days of my life happened after the assault. I have a civil case right now for the facility failing to keep me safe. My case has been brought under Georgia law that requires businesses take reasonable steps to keep people safe like me. During the case so far, we have learned from police reports and prior employee testimony about the sexual assaults that occurred just like mine. In rooms with adolescents left alone and unsupervised, these other survivors' assaults happened just months before mine, but nothing was done to protect me from the adolescent placed in a room with me. We have also learned of a policy to check on children every 30 minutes at minimum. No one ever checked on me in my room on the night I was assaulted. Right now, the law in Georgia allows me to seek justice and accountability from the facility that I believe was negligent. I'm here today to share my story with you, and I hope it helps you understand how people like me need protection. SB 68 has to be amended to protect vulnerable children. What happened to me never should have happened. I deserve to be protected. Please protect others like me in the future. Thank you.
Thank you. I don't see any questions. Thank you for your testimony. Sarah Schneider.
Thank you. Can you hear me? Is it good? Yeah? Perfect. Good afternoon. My name is Sarah Schneider. I'm the mother of 3 boys, 2 living and 1 is deceased. I'm an author and a speaker, but most importantly today, I am the founder and president of Bowen Walker Foundation. We are a 501c3 nonprofit that nationally serves families with grieving and bereaved children who experience loss and trauma through death by providing personal and community-wide education, support, and resources. All of my work and what I do is to support families who have had a child die, be killed, or seriously injured. As an organization, we serve families all across the country, but Georgia, Barrow County specifically, is my home. Last September, our small town was devastated by a shooting at Appalachia High School. Since then, I've been heavily involved in supporting and working with families of both the injured and deceased. Much of my work is helping to identify and obtain immediate and long-term financial resources, finding, connecting, and arranging specialized counseling, as well as providing other resources for our grieving families. There are very few resources available to crime victims, especially children. As it currently stands, the State of Georgia Crime Victim Compensation Fund only provides a maximum of $25,000 per victim, total. That includes medical bills, therapy sessions, lost wages, and as anyone who has ever paid a bill, you know that those expenses add up fast. These are just a few of the things that fall under this $25,000 umbrella. I'm not a lawyer, but as I understand it, current Georgia law provides a way for some families to hold negligent property owners responsible when victimized by crime, something that would be made much more difficult, maybe impossible, for every survivor if SB 68 is passed. On behalf of the many innocent families who will undoubtedly be dealing with a death or serious injury due to crime, I urge you to be very careful about making any changes to Georgia law that might make it even more difficult to hold anyone accountable for failing to prevent violent crime. Thank you.
Thank you. I don't see any questions. Thank you.
Thank you.
Kara Phillips.
Thank you, Chairman. Thank you, everyone who's here. Thank you to all of the people who have shared their stories. Very briefly, I'm here testifying again to address comments by Senator Kennedy and Governor Kemp in response to my and Susan Kopp's testimony last week regarding the scope of SB 68. I want to say I'm relieved to know that apparently we are aligned. Nobody wants the Cobb family to be barred from claims. I've heard stories about sex trafficking survivors. No one wants them to be barred from their claims. And so I want to just echo the voices that have pled for an amendment here, but I want to make sure we're really clear. The sex trafficking piece was very clearly explained to us, the way that the scope of this is so broad that it eliminates these kinds of claims. Well, in particular in the Cobb case, which was talked about last week, and Susan is back here today simply because of her concern about SB 68. In that case, and Senator Kennedy stated, the language of the bill does not and would not impair her claims. And I want to make sure on behalf of Jennifer Cobb that it's very clear what we're talking about. In her claims, on or about July 17, 20 13, YMCA hosted the Twisters, that's the gymnastics team, for an overnight lock-in. Jennifer was 12 years old. Though he was no longer employed as a coach, Bob Green, aged 28 years old, attended the event at the invitation of the other coaches, and during the lock-in, they went missing for 3 or 4 hours. He lured Jennifer into a single-stall bathroom alone with him. During that time, he molested her. He tried to bring another girl into the room. And these claims are set out at length in the complaint. Other coaches saw him kissing Jennifer. There were numerous opportunities to intervene on behalf of the Cobb family by the YMCA. And so in response to Susan's testimony, Senator Kennedy stated that her claims would not be impaired. However, it's very important, and also, of course, we've got a letter from Governor Kemp to this committee, which I'm sure everyone has seen, that says the only claim that could plausibly be impacted is her premises claim. What's been talked about, the very beginning of this bill defines the negligent security cases to be anything sounding in tort or nuisance that involves a property owner and an injury and a third party. So that is broad enough to include claims beyond 5131 for premises liability. It includes claims for just simple negligence, let's say a failure to supervise. That falls here as well. And last week I handed out an amendment that provided a carve-out. It's right on the heels of the attempted carve-out for sex trafficking. But the carve-out is for children, is for all sex assault survivors, some of whom we have heard from today, and it's for the elderly. And the reason for that is that they are the most vulnerable. And here we have cohesion. We have a senator who's pushing this bill and who does not want to eliminate these claims. We have a governor who has no interest in taking away the rights of these survivors, but we have a bill that needs to be amended desperately. And I'll just keep moving quickly and just say we're dealing here with the physical condition, the substantially greater risk language. We could eliminate that and we could protect a lot of people. But if we can't do that, we have got to carve out these vulnerable individuals.
Last week you handed us a proposed amendment which I think does take a lot of the paragraphs which refer to physical condition and also has an exception clause in it as well, correct?
That's right, 2 options. Take something out, put something in, absolutely. Okay. And if I may, Chairman, there are other survivors here who are not able to testify right now because of confidentiality provisions, because of the impact on their mental health, and I'd like to take a moment to have them stand up if they would otherwise like to be testifying, but they'd like to be acknowledged right now. Thank you very much. We appreciate the time of this committee.
Thank you. I believe you have a question, Representative Evans.
Thank you, Mr. Chairman. Thank you for being here and for clarifying that. I want to make sure that it's clear for the committee, because you brought it into crystal clarity for me just now. On line 163, because we define negligent security to mean any claim against an owner or occupier or against a security contractor, that's why whether you call it negligent hiring, whether you call it negligent supervision, whether you call it nuisance, whether you call it negligence, whether you call it whatever you call it, we are looping those in by the definition on line 163, and that's the concern for Ms. Cobb and others.
Exactly. I was very glad to hear the analysis by the attorney who does sex trafficking because it's identical. Exactly.
Thank you.
Thank you. I don't see any other questions. Thank you. All right, is it Lakia Reed? Lakia.
Good afternoon, Chairman and respected members of the committee. My name is Lakia Reed, and in 2011, I was paralegal at the Lindsay firm and a law student with a firm represented 2 young boys, ages 1 and 2, whose mother, Tamara Reed, was murdered in an apartment complex in Newton County. Tamara was visiting her sister when she was shot to death by a resident who should have never been living there. Today I stand before you as an attorney and an owner of my own law firm in Conyers, Georgia. Prior to Ms. Reed's murder, the apartment complex was responsible for reviewing applications submitted by people who wanted to live there. Part of the application required the prospective tenant to answer questions about their criminal history and to agree to submit a background check. Before offering anyone an apartment, the apartment complex was required to determine whether the applicant had been truthful about their criminal history, and to determine whether there were any offenses on their criminal history that would disqualify them from the applications. All these requirements were in place to prevent dangerous persons from living at the premises. During discovery, it was learned that for years prior to the shooting death of Ms. Reed, the management company failed to properly screen the applicants and criminal histories of numerous applicants, routinely violating its own policies by providing apartments to people who were not eligible for housing because they had lied about their criminal histories and or had lied about their history that would disqualify them from being eligible for housing. One such applicant at this apartment complex improperly provided an apartment to was Willie Gunn. Mr. Gunn applied for housing. He told this company that on his sworn application and during a face-to-face interview that he had never been arrested or convicted of any crime. As a part of the application review process, the management company obtained a copy of his criminal history, which not only showed that he lied on his application in his interview, but that he had actually been arrested and convicted of at least 4 crimes, including a conviction for sexual offense involving a minor and conviction of murder. However, despite him providing this fraudulent information and his criminal history, and despite this criminal history being provided to the management company prior to providing him an apartment, he was allowed to live at this facility. He then moved into this apartment and some months later shot Ms. Reed to death while she was visiting her sister, leaving her mother to raise her 2 young boys. The apartment complex was sued on the theory of premises liability pursuant to the duties set forth in OCGA 51-3-1, that an owner or occupier use ordinary care to keep their premises safe. A jury found in favor of the plaintiff. If this same set of facts were to arise after the passage of Senate Bill 68, there would be absolutely no remedy for the owner's obvious and outrageous failure to use ordinary care to keep its premises safe. And I will point you to lines 163 through 169 and 254 through 257. Plain and simple, SB 68 would completely cut off the remedy currently available against an owner or occupier where a third party wrongful conduct owner results in injury for failure to, or the occupier to keep the premises safe from conduct of a third party. This is the sole and exclusive remedy. In this particular case, the owner's numerous and inexcusable failures had nothing to do with the third party exploiting a specific physical condition of the property, which would now be specifically required under the new statute, because this will require, as stated in lines 224 through 228, such wrongful conduct by a person was reasonably foreseeable consequence of such third exploiting a specific physical condition of the premises known or the occupier or owner, which created a reasonable foreseeable risk. It simply doesn't make sense to ignore the obvious facts that the failures and negligence of property owners cannot and does go often, but far beyond their failure to provide some sort of physical security measures such as fencing or gates. And this is particularly true when talking about many people who are victims of crime at apartment complexes, where the landlord fails to do proper background checks on the residents or fail to take action when the residents are known and they know the risks due to the presence of other residents or their guests who may be dangerous. Even more concerning is how one could read the blanket exceptions provided at lines 262 through 289. Specifically, at 272 through 274, as it's framed, could be led to perceive that when a tenant harms another occupier has no liability, or at very least has no liability during the eviction proceedings. As someone who has seen firsthand knowledge of how careless actions of an irresponsible apartment owner can devastate and rip families apart, I ask you that you work on this bill to make the citizens of our state safe. We all want safer communities. We do not want to disincentivize safe apartment complexes. Thank you.
Thank you. I don't see any questions. Thank you, ma'am. Andy Rogers. Good afternoon.
Good afternoon. Thank you, Mr. Chairman. Thank you for patiently hearing from the voices that need to be heard. And I had a bunch of points that I have now checked off my list because others have gotten to them. But there are two others that I think are really important here as it relates to what is currently in this bill. It was touched on briefly, and that is the clear and convincing evidence standard or burden of proof, which exists nowhere else concerning any other personal injury claim of any kind in the entire civil code. It is reserved for punitive damages proof. It is reserved for fraud actions, and it has no place in a claim for personal injury. It never has had a place. It's not time to create a new burden on a class of cases that are already almost impossible to prove.
And you're referring to the language on line 210?
Yes.
I think that's the only place it appears.
Yes, yeah, that's the only place, but it gets everything. It encompasses everything except for knowledge of somebody on the property, somebody they already know about on the property. Back in 2005, I don't know if any of you folks were sitting in your positions at the time. There was a single effort to deal with these negligent security cases under the guise of tort reform, and it was not a new statute, it was a rewriting of a statute on non-party apportionment. This is not going to take that long. That was 2005. In 2012, I was at the Supreme Court of Georgia arguing that case to determine whether it was constitutional, or whether it should be allowed to be used the way it is now and has been used for all this time. That was 2012. It took 7 years for that single change in negligent security cases to make it to the Supreme Court. We heard earlier there are 10 or so knowledge requirements in a single paragraph of this proposed statute. You can be guaranteed that there is going to be at least 7 years of litigation over what a single paragraph of this omnibus bill actually means. If you're okay with that, then pass it. If you're not okay with it, then work on it. Apportionment has reappeared or reared its ugly head once again. And I want to make sure nobody has talked about this, but it is yet another unfair burden on a already overly burdened, overly traumatized, completely innocent crime victim. Why? Setting aside bifurcation, this bill would require multiple retrials of the entire case if a jury does not completely on its own apportion at least 50% of fault to the non-parties. I'm not making this up. I'm not putting a spin on it. That's what it says. And it says that there will be a rebuttable presumption that the apportionment was not done correctly if it doesn't reach at least 50%. This is a big deal. It is a big deal because it's gonna get litigated again all by itself. It's gonna require victims to testify an infinite number of times, and I'm not exaggerating, until the jury gets it right. And you know what else? The lawyers are not allowed to talk about what apportionment actually means. That's the rest of this part of the statute.
And you're talking of what would be codified as 51.356.
I am, and it's
lines 304 to 330. I think the particular paragraph you're talking about is 323 to 330.
And this kind of apportionment, it exists nowhere else in Georgia law, and it should not start here. Thank you for your time.
Thank you. I don't see any questions. Jervina Moody. Afternoon, Ms.
Good afternoon, and thank you to the chairman and committee for allowing me to testify. My name is Jervina Moody. I am here today to talk about the worst day of my entire life. In August 2016, I was living in an apartment complex in Southeast Atlanta. I had moved there from Florida with my children to be closer to my mom, who lived in the same apartment complex. I was working full-time as a medical assistant. I was a proud, hard-working single mom. My mom had picked the apartment complex based on the apartment's assurance that it was safe to live with supposedly security on site. On August 1st, 2016, I had been living at the apartment complex for a few months. The apartment sent out an email a week or so prior that a robbery had taken place, but that management had no reason to believe that anything else of that nature would occur. The notice did not say that there had been 4 armed robberies within 30 days. The notice did not say that 3 of the armed robberies had taken place within 2 weeks prior. The notice also did not say that all of the armed robberies occurred in the parking lot. Additionally, the notice did not say that they believed the same suspect committed all 4 armed robberies. Finally, the notice did not give a description of the suspect, which we later learned had been given to property management by the police. None of us at the apartment complex were aware of what property management knew, that a dangerous resident with a unique build and hairstyle was on a crime spree of armed robberies with the same gun in the same parking lot. On the evening of August 1st, 2016, I became his 5th victim. That evening, I came home from work, picking up a friend on the way. My mom was watching my children at her house. When I arrived home, I dropped my things inside and changed out of my work clothes. My friend and I went back to my car in the parking lot to head to get my children. As we were sitting in the car in the parking lot, getting ready to leave, a man came up to the window with a gun and ordered that I give him my purse. I told him I did not have it. My purse was in my apartment. At that point, he ordered us out of the car and told me to take him to my apartment. He followed us by gunpoint to the apartment. Once inside, he ordered me to get naked. Terrified and trembling, I took my clothes off. He told my friend to watch. He ordered me to get on the ground. He put the gun to my head, and I cried out to please not kill me, that I had children and I was a mother. He then violently raped me. At the end of the raping, he looked at me while I cried and pleaded with him. The gun still to my head. He said, "Are you ready to die?" He then pulled the trigger, and the gun had jammed. I was frozen and terrified. He got angry and ordered us into the bathroom and told me to lock it and take a shower. And if I came out, he would kill us. We waited for seemed like forever until we hoped he was gone. I then threw on a towel and I ran out of my apartment to the neighbor's door, screaming for help. They called 911 and the police came. My mother and myself moved out of the apartment complex the next week, while also learning that I had contracted an STD from the rape. In the course of the police investigation and subsequent civil lawsuit, we learned that despite of their advertisements of security on site, the apartment complex did not have security guards. At the time this happened to me. We learned that in the 2 years prior to my horrific robbery and rape, police had been called over 130 times to the apartment complex for violent and parking lot related crimes. Despite knowing about these crimes, the apartment complex only security was 2 police officers that they gave a discount to park their police cars in the parking lot while they were not out working their off-site police jobs. Both police officers testified that they recommended to property management to have dedicated on-site security and that property management ignored their requests. I was the 5th resident to be robbed by gunpoint in the parking lot within 30 days. Clearly, the robber knew that he could get away with my robbery and rape because management had done nothing after the previous 4 armed robberies to prevent further parking lot crime. They also had not warned us residents of what they knew, that a dangerous resident with a unique build and hairstyle was on a crime spree of armed robberies with the same gun in the same parking lot.
Ma'am, you're at 5 minutes if you'll try to close for me.
Okay. In the days, months, and years following that night, I have struggled with depression, anxiety, suicide attempts, nightmares, PTSD, and severe emotional trauma. Through a lot of counseling, I have learned to cope with what will haunt me for the rest of my life. Please do not insensitize apartment complexes and businesses to choose profit over people like mine did. Please stand up for the innocent women and mothers like me. Thank you.
Thank you. I don't see any questions. We have Madeline Simmons next. Thank you. Natalie Woodward. Thank you. Mike Rafi.
Thank you very much, Chairman. I've always said we could get all of the negligent security lawyers in one room together pretty easily because there's not many of us. So I want to talk to you about the lawyer side of things. There aren't many lawyers who handle these cases. I am one of them, and the committee has heard from so many others, but there's not many more of us. This is us. We are the people helping these victims, from John to Andy and Gil to Michael, who hasn't talked yet, to Natalie, who's leaving, to everyone in the room. We are the people that are defending these victims. My firm turns down 59 cases, 59 negligent security cases for every one we take. Why don't you see billboards about negligent security cases? Why don't you see TV ads? Because they're so difficult and they're so expensive. The average case costs tens of thousands of dollars, sometimes hundreds of thousands of dollars, and to even figure out if you have a case, you have to spend months waiting on police reports, investigating. You don't know if you have a case until 6 months, 7 months later. So the cases that have been discussed today, these are the ones that navigated through that difficult journey and then got here and got to a verdict. My firm currently represents 50 people who are victims of violent crime and negligent security cases. Not a single case would exist under SB 68. Not a single one. I've represented hundreds of people. Not a single one of them would have a case. This eliminates the incentives for any business to protect their customers. Now, last week, this committee also heard about a supposed another victim, a single mother who was hit with a $1 million lawsuit. Do y'all remember that? That was testified last week because there was a single mother in a car crash who got a verdict against her for $1 million. It was because of the tricky plaintiff's lawyer and the favorable laws that helped that verdict come to be. I was that lawyer who represented that plaintiff. And it wasn't a $1 million verdict, it was a $1.5 million verdict because $500,000 was tacked on for a frivolous defense. Out of any case to use as an example in this body, the past president of the Georgia Defense Lawyers Association came here and testified about a case where there was a $500,000 penalty against the way that that lawyer and that insurance company defended the case. The purpose of this committee is to weed out frivolous lawsuits, and I will tell you that the plaintiffs' lawyers here today, we are your first line of defense. We work for free and we pay our own money. We don't want frivolous cases. By definition, those means we can't win. We're wasting our time, we're wasting our money, we're wasting our energy, and we don't need to do that. So you have the right people in the room, and we are willing to work through these matters and give you the correct information. I've never been in this building before. I think that makes me a bad citizen, a bad lawyer potentially. I'm here because last week my phone was going off the hook with people telling me, hey, one of your cases is being discussed. And I said, I watched the tape back and I said, that's not one of my cases. That was my first reaction. And then I watched more and I said, well, that actually is. My client in the case with the mother who had a $1 million verdict against her, my client was 25 years old. And the frivolous defense was that he caused the crash when he didn't. And a 12-person jury in Gwinnett County said otherwise. And the frivolous defense was that he had already hurt his knee prior. And a 12-person jury said that that wasn't true. And if you don't give people their right, their ability to get in front of jurors and to get any 12 people to agree to one single thing on this earth is a monumental task. And we have 12 jurors in all of these cases agreeing that crime victims have rights and should be compensated, that the people that don't protect their customers should be penalized, and that insurance companies in car cases, when they don't behave properly, when they behave poorly, they should be penalized too. And I'll note that the frivolous defense, the money assigned for a frivolous defense was under Section 91168E, which was a bipartisan passed bill sponsored by the Georgia Defense Lawyers Association to prevent frivolous lawsuits. And here they came before this committee and testified that there was a frivolous case when they were assessed more than $500,000 in that case. So I urge you to trust your sources.
Thank you. I think you have one question from Chairlady Miller.
Thank you, Mr. Chairman. Just a question for you. One of the thank you for explaining the way that you guys get paid and the way that these cases come about. So you don't get paid and you finance the litigation. That's pretty much how this works, right?
Yes, and it's more expensive than the college tuition for my 3 kids at home, so we're talking very real money. So every lawyer has the incentive on my side to make sure that we're making very, very good decisions. And I will tell you that the way the law is written now, let alone the changes that are proposed, the way the law is written now is that innocent people do not get representations because the risk is too great. And we are going to make it now that you asked Mike Moran, I think you asked Andy Rogers about, I think they were both asked by questions about what case would survive this. I will tell you, I've had more than 250, maybe more than 300 of these cases. Not a single one will survive.
And a follow-up question to that. So the lawyers who are on the other side, who are representing the defendants and or sometimes the insurance companies, how do they get paid?
Yeah, so a lawyer, an insurance defense lawyer, which I was a defense lawyer for years, they are hired, they have a business relationship with the insurance company. And then when Joe Schmo, the insurance company's insured, their customer gets sued, then the lawyer is hired to represent the insured. They don't pick their cases. They are assigned the cases by the insurance company. And it used to be you'd make a phone call 10 years ago as the lawyer and you'd settle the case on the phone. That was the way it used to be done. Now, the defense lawyer has to go to their insurance adjuster. The insurance adjuster has to go to 5 other people to get permission to settle the case. And the cases drag on, and there's no real penalty for the defense lawyer for bringing a frivolous defense. I will tell you, for every one frivolous lawsuit, there are thousands and thousands of frivolous defenses. I have cases with rear-end crashes where the defense is my client caused the rear-end crash. I can tell you 50 of those right now. So there is no disincentive to not bring a frivolous defense other than Section 91168, but an injured person has to go all the way down the line to trial, and that takes years.
And in fact, they get paid by the hour typically?
Yes, they get paid by the hours. The more trial, the bifurcated trial, they will make more money.
Okay, thank you. And then lastly, I think you were accused by the lawyer who came in last week of refusing to settle the case within the insurance policy limits, which she represented were $100,000. Can you tell us whether that's true or not?
I'll tell you, I don't know how to answer a yes or no. I'll tell you that's true, we did refuse, but what's missing is context. And what happened is before the lawsuit was ever filed, my client had a knee surgery and had 3 herniated discs in his neck. He had $82,000 in medical bills. Not his choice. Completely fine before he got in the car to go pick up his dad at Home Depot that day. And he gets in this crash. Police officer finds that the single mother was driving without a license, shouldn't have been driving, and arrested her at the scene. This is the innocent person that was propped up in this committee. So my client has $82,000 in medical bills, 3 permanent herniated discs, and long-term pain and suffering on his knee. He will likely need a total knee replacement as he advances age, and maybe 2, given he was only 25 years old. So we tried to settle the case for $100,000 twice.
Thank you.
Twice. And after 4 years, 5 years, maybe 4 or 5 years, then you have a verdict 4 or 5 years later, which my client had to endure. That trial never should have happened. And that case was frivolous. It was just on the defense side.
Thank you. Nicole, is it Buckwalt? That's right. We didn't give you a lot of room there. When you're ready, Ms. Buckwalt. And just so everyone knows, I've got 1 or 2 more opposed, and I think we'll take a break because we've got about 8 in support of, and then we'll come back. But let's keep going for now.
Thank you, Mr. Chairman, and thank you to the members of the committee. My name is Nicole Buckwald, and I am here as a lawyer. But more importantly than that, I am here as a Georgian citizen. I was born here in Northwest Georgia. I went to UGA for college. I went to Emory for law school. This is my home. I became a lawyer because I care about people. What we're here to talk about today shouldn't be about politics. I have a lot of colleagues on both sides of the aisle. We can all come to an agreement on this. When I was in high school, I won a scholarship because I wrote a GOP-sponsored essay on the rights of citizens in our state. This is what I care about. This is the state that I have decided to raise my family in, and that I am committed to protecting. You've heard a lot from a lot of really talented lawyers and a lot of victims. What I don't want you all to lose sight of is there are so many more victims that could not come here today. I can't tell you how many of my clients would have loved to be here, have stories that matter. Clients who lost their children, clients that were shot on their property, clients that survived domestic violence only to be attacked when they were promised safety. Pregnant women sleeping in their beds, doing nothing wrong. Gunned down in crossfire when the apartment complex knew repeatedly that there were other people being targeted that were a problem. 3 times. They didn't do anything. I've had litigation at that same complex numerous times in years prior. SB 68 will do one thing. It will provide immunity for big insurance companies, for corporate America, and do you know who is at risk at this? Georgians. I went to law school because I believe in the civil justice system. I believe that it is the last great balance that we have in our society to protect our freedoms. But what this bill will do is increase violent crime. It will increase trafficking. It will increase rape, aggravated assault, and murder. It will make Georgia a sanctuary state for crime. And I am confident that that is something that not a single person in this room wants. This bill creates an unprecedented immunity that goes well beyond any other law in the country. We talk a lot about what happened in Florida 2 years ago, but do you know what we haven't talked about yet? The investigation that the Florida House of Representatives is currently doing because the data that supported their bill was fraudulent or misleading at best. There's money shifting going on. That's not my word. That's how it's being talked about in the media. I can pass around plenty of documents to show that. If we want to pass a bill, which I promise you all of the lawyers in here, we would love to work together and to be in the room and to offer changes. And you've heard a lot already. What I will also say that echoes what my colleagues have said, not a single one of my cases would survive under this bill. I can't come up with a fact pattern that would survive under this bill. Not a single situation where a child is murdered in their apartment that would survive under their bill. That is not good policy for anyone. We've all been in grocery stores, in malls, certain malls that aren't that far up the road that have increased security. They have metal detectors. They have off-duty police. They've gone above and beyond, frankly, because they've been hit with lawsuits. But do you know what those lawsuits did? They made us safe. When this bill goes through, if it does as written, do you know what will happen? We will be unsafe. Those businesses will have every incentive to pull back the security measures that they have in place. They will pull back the armed security that's there, the metal detectors. It will not be there. Our country knows how to band together to deal with complicated issues. What I'm asking this committee to do is to work together. If we want to stop crime, let's figure out how we can do that if that's really the goal here. If the goal is to stop insurance hikes, let's figure out why the insurance companies are struggling and let's hear from them. Let's hear their commitment. Why was the amendment to limit insurance hikes not included? If that's what this is really about. But that's not what this is about. If we don't want to be a country of over-regulations, the civil justice system is the only answer to protect our citizens. I have a lot more that I would love to say. I know my time has run. I know y'all have heard a lot from a lot of people. So I do want to thank you for your time. If I or any of my colleagues can answer other questions, I feel like I can speak for all of us and say that we are more than willing to, because we don't want a strict liability standard on good businesses in Georgia. We want a reasonable standard that encourages safe businesses to exist in Georgia. We can all agree on that.
Thank you very much for your testimony. I don't see any questions.
Thank you.
We appreciate you coming today. Michael Smith.
Good afternoon, and I'd like to thank the committee for the time to speak here today. My name is Michael Smith. I'm an attorney here in the Atlanta, Georgia metro area, and I have chosen to dedicate my life to representing victims of crime. And I also want to thank my colleagues that appeared here today to give their remarks on the SB 68 bill. I think collectively we've touched on a lot of points here that are substantive problems with this bill, and in particular the fact that this bill as drafted would, I think you've heard from numerous of us today, would effectively kill most negligent security cases that we know. And in thinking about, without going and rehashing the points that I think a lot of my colleagues eloquently have kind of touched on, I mean, that is the reality that we face here today. This committee, if they vote this bill into law, will effectively be condoning and stripping the rights of Georgians to hold property owners in this state accountable for crimes that they were fully aware of. And I think that's important to keep in mind here today, is that a lot of these apartment complexes and I do work with a lot of folks that are victims of criminal apartment complexes. These apartment complexes are owned by equity funds that are not based here in the state of Georgia. They do not care about the safety of Georgia residents outside of being held accountable, which, and I know some folks may say, well, that's what the police are for. The police can go and handle these things. But these businesses, these equity funds, have chosen Georgia to purchase businesses, apartment complexes, places where our fellow citizens reside. And there is an expectation, there should be an expectation in this state. I would think that there would be an expectation among all of you representatives here, that your constituencies, the people in your constituencies that are paying rent to these equity funds that are coming from out of state, from California, from New York, because they see Georgia as ample grounds to make money off of where people live, that there should be some expectation that our fellow citizens should be kept safe. And that should not all be shifted to law enforcement. There has to be some responsibility placed on landowners and owners of businesses to, if you're going to have somebody come to your place and stay and pay you rent and you profit off of being in Georgia, there is some responsibility that you owe citizens of Georgia to keep that property safe. And this bill is condoning and immunizing owners of properties from being held responsible for failing to keep Georgia citizens safe. And that should be unacceptable. It's effectively immunizing insurance companies from being held accountable as well. I mean, I know that the point of this bill, from what I understand, at least the little bit I've heard, is that this bill was designed to give Georgians relief on insurance premiums. And we have yet to hear a testimony from a single insurance company about how the provisions of SB 68 are going to lead to a reduction in insurance premiums. And then a step beyond that, we have yet to hear from any insurance company about how the provisions of SB 68, how much of a reduction are Georgians going to expect? Because I would like to know what is the price tag that Governor Kemp is going to put on stripping Georgians of the right to hold landowners accountable? And I believe the chairman, you got a letter from Governor Kemp on the 7th of March, and I read that letter, and I had some questions for the governor based off of the standard that he's articulating, that you should scrutinize the plaintiffs' counsel and Georgians who are having issues with SB 68. He came out of the gate and said that we're supposedly saying that this is repeating misinformation and mischaracterizations of this bill. This is not mischaracterization. This is not misinformation of this bill. If you send this bill into law, you are killing Georgians' rights to hold landowners accountable. That is not propaganda. That is the truth. And you've heard from numerous practitioners here today that is the reality of what will happen if this law goes into effect. But he urged this committee, when talking about, I think there was a letter from the Mothers Against Drunk Driving, he urged this committee to examine the veracity of the claims being made by the Mothers Against Drunk Driving. And I would submit to you that there should be an onus on this committee to use the governor's own standard when assessing the reason for pushing this bill through. You need to examine the veracity of whether or not Georgians are indeed going to get a reduction in insurance because of these provisions. And if so, how much? Because I think Georgians should know how much of a benefit that they're getting from insurance companies and whether that benefit outweighs the ability to go into a court of law and hold a business owner accountable. And that is why this committee should consider amendments and should, at a minimum, vote no on SB 68, because there's no guarantee that the insurance company is going to reduce any insurance premiums. And indeed, I have yet to hear Mr. Kennedy give any evidence that you can examine the veracity of to support that conclusion. And I'll yield my time.
Thank you, sir. All right. All right, that finished the first page. We've got two more opposed. We have KH. Did you want to ask a question? Well, all right, hold on one second. Mr. Smith, yeah, we have one question for you. I tell you what, do you have a mic over there at your desk? Why don't we try that? What would that be, 25? 24. All right, go ahead, Representative Evans, why don't you ask a question?
Thank you, Mr. Chairman. Sorry, my button was just stuck, and so that's why the delay. Thank you for being here, Mr. Smith. I just wanted to ask for clarity. You represent a lot of apartment complexes and, represent a lot of people who have to sue apartment complexes for negligent security cases. In your experience, do a lot of these apartment complexes where there's this rampant crime, isn't it true that they also advertise and sort of lure customers in by saying, this is a safe place to live and we're going to have security and we're going to have gates, and then that turns out not to be true, and that's part of why they're responsible, and it's not just the cops. Would you agree with that?
Yes, and I apologize to everyone for my zeal. I'm very passionate about representing, and I do want to say that, I'm gonna get to your question. I do want to say this is not a bipartisan thing. I've represented Democrats, Republicans, they have been victims of crime. We may not have seen eye to eye on politics, but one thing we do see eye to eye on, and what I believe in, is that they have a right to be heard in a court of law. And to answer your question, yes, you would think from some apartment complexes that I've seen that have been terrible and had rampant crime, you go to their website, you get their advertising, and you would think that they were the safest place that ever existed in the state. And they're saying we have security, we have vehicle access gates, we have pedestrian access gates, you can only get in if you have a key card. And the reality on the ground, and inevitably somebody gets shot and killed, or somebody gets hurt, you have to go out to the property and you walk around and you realize that it is so far from the truth. And who's left to deal with that is, your innocent crime victims who they don't know. They just need a place to stay, and they believe that they have chosen a place that is safe for their family, and the reality that's lived on the ground could not be further from the truth. And the entity, and like I said, this is private equity. This isn't your mom and pop landlord from back in the day that lived in the neighborhood, that if they were a slumlord, there would be some community pressure that you could exert on them to shame them the fact that you shouldn't be maintaining your property in that way. These are folks that are in New York and in California that just see each unit as a profit center, and they could care less about Georgians. And so, yes, they do lure folks in, and they must be held accountable. And like I said, SB 68 is just giving a green light for private equity coming here and just create slums in Georgia, and that just can't be acceptable.
Thank you. All right. Sorry, ma'am, if you'll go on back up to the podium. I've got the mic on for you.
Good afternoon. I wish it could be a pleasure. Well, I'm sorry. I wish I could say it's a pleasure to stand before you today. But the truth is, this moment is very hard for me. I am a survivor of sexual assaults. At just 18 years old, only months away before I was preparing to leave for college, my life changed forever. I'm here today to make sure my voice is heard, to stand in the gap for those who wish they could speak but cannot, for those who've struggled to get here in this moment, and to have this moment and did not make it. I am here yet again. My life changed forever on the 4th of July when I was attacked outside my residence. I would not wish this pain I have endured on my worst enemy. After that night, I did what most After that night, I did what so many survivors are told to do: seek counseling. Though no one considers the financial burden or the years it takes to heal. Move on. Though my family was displaced from my home after my attack. And forget about it. As if I could ever erase the memory of my own screams, with a gun being pointed to the head and being raped on the side of my apartment building. Seeking justice was everything I wanted, but not for the money, just accountability. And nearly 10 years later, I'm still here fighting. My civil case was not about financial gain. It was about holding those in power accountable for their reckless actions and for their failure to provide safety to those who lived and entered their property. Justice did not come easy for me. This civil case took years. Meanwhile, the man who attacked me, a serial rapist, continued to roam free. 4 years after my assault, he was finally arrested after victimizing 9 women in the same area. And in 2023, I finally received that justice when he was sentenced to serve his time in prison. Disbarring the civil cases like mine does nothing but protect those who should be held accountable. It does not protect victims. It silences us. It tells survivors that our trauma is not real, that our pain is forgivable, and that our fight is not worth the court's time. I urge you to consider the devastating impact of this decision. Survivors and victims deserve justice. We deserve to be heard. Because here I am again, me versus my residents, me versus my rapist, and now me versus the state of Georgia. Thank you.
Thank you, ma'am. Thank you for your testimony. And our last opposed witness is former Representative Matthew Wilson. I would acquaint you with the operation of the podium, but I'm sure it's a position you're familiar with over there. So
it's good to be back, Mr. Chairman. I have some grievances. I'm kidding. Thank you very much for recognizing me, Mr. Chairman. My name is Matthew Wilson. I had the privilege of serving 4 years in the State House representing DeKalb and Fulton counties, and served with almost every member of this committee. So it's good to be back, and I appreciate you giving me just a few minutes of your time. I was not planning on being here, Mr. Chairman, but I've been watching these hearings very closely as a trial lawyer who will be affected by this bill. Certainly my clients will be affected by this bill, and felt compelled to come and share some feedback on some blatant untruths that this committee has been told over the last 2 weeks. I think it was 2 weeks ago, you were told that this bill has nothing to do with insurance companies. It has everything to do with insurance companies. Everything to do with insurance companies. And we know that because the intent behind this bill was said to lower insurance premiums for everyday Georgians. And we all pay insurance, so we all know the premiums are too damn high. The question is why? And what levers can we pull to actually decrease those premiums? Well, the insurance commissioner told the Senate this bill will not decrease insurance premiums. He's told legislators who have asked him one-on-one, will this decrease premiums? How long will it take? He said maybe 10 years. It may never decrease the premiums. Yet this committee was told we need this bill because insurance companies in Georgia are losing money. Please show us that somewhere, because I can tell you that the Trial Lawyers Association, opponents of this bill, have been asking since the end of last session for proof that insurance companies in Georgia are losing money. The Insurance Commissioner's Office has so far not produced any evidence whatsoever that insurance companies in Georgia are losing money. And you were told 2 weeks ago by the carrier of this bill that insurance is effectively a pass-through program now, that our premiums are going to fund these so-called nuclear verdicts. We know that's not true because that's not the only pot of money insurance companies have. Insurance, I know a thing or two about this because not only have I sued insurance companies, but I ran for insurance commissioner when I left this chamber. Insurance companies are allowed to invest our premiums and keep the investment income that they earn from that. They have two pots of money, the premium pot, the investment pot. They have come to us and said to you, we are losing money out of this premium bucket. Please help us. What they haven't mentioned, talked about, haven't even come here to talk about, is this other massive bucket that they have of money. In 2023, the last year we have full data for, over $100 billion was in this bucket. And did they have to take some $12 billion and move it over here to this pot? Yes, they did. That's how insurance is designed to work. That's why we allow them to take our premium money and put it in the market. We want them to make a profit. We want them to provide the service that they provide. But that doesn't mean they get to keep this money. They want to say this bucket over here is their money. This is y'all's money. This is our money. The only reason they have money in this bucket is because the state of Georgia requires us to pay our premiums. And you've heard a lot about the tort reform bill that was passed in Florida 2 years ago, and I want to point out two things very quickly, Mr. Chairman. One fact that you were told was that Florida recently announced the lowest average homeowners insurance premiums in the entire nation. That is blatantly false. That is not true. I believe that was based on a press release that Governor DeSantis released that said Florida may, keyword there, may, it's unverified, have had the lowest average homeowners insurance increases in the country. Given all that's played out in Florida over the last week with the Florida House Speaker impaneling a committee with investigative and subpoena power to bring the insurance companies to bear to find out, to get to the bottom of this expose that was published by the Tampa Bay Times, I think that gives this committee, should give this committee a lot of pause and say, what is the rush here? This bill has everything to do with the insurance companies. We know this bill will not lower premiums. We've all been told that. You heard today who will pay the costs for this bill. It will be the victims. And not just the victims you heard from today. We know that their lawsuits their right to seek justice will be impacted. Their lawyers came here today to tell us that. You don't just have to take their word. I'm sure that the proponents of this bill will acknowledge their powerful stories. And I'm sure that they may even say some of their cases should be allowed. None of the cases that you heard about today will be allowed after SB 68 passes. I would urge you to hold this bill, and it'd be a great opportunity for a study committee, Mr. Chairman. Thank you.
Thank you, sir. You have one question, or a series of questions possibly, but I said I didn't mean to limit you to one question. I said you have a question, but you're free to ask questions.
Thank you, Mr. Chairman. Thank you for coming. I just want to ask you a couple questions about the Florida situation. Is it not true that the arguments that were being made in favor of tort reform in Florida bear a striking similarity to the arguments that are being made for tort reform here in Georgia?
Oh, it's the exact same argument. It's the same argument. The argument in Florida was, we are losing money in Florida. We're taking in premiums. We're having to pay out more than we're making. We're losing money here. And what the Tampa Bay Times expose revealed was, while the insurance companies were testifying to that before the legislature, they were moving billions of dollars in investment income to affiliates so they would not have to report it to the insurance commissioner. And it was, interestingly, the insurance commissioner's office that discovered this. They wrote a report that they very quickly listed as a draft and shelved it in a drawer so they wouldn't have to produce it to the legislature, but it came out through an open records request. That's why you see so much anger from the Florida House Speaker and from the legislators there, because they know they were bamboozled. And if this committee will listen, the Florida House Speaker and the Florida legislature are begging others not to be bamboozled by this same argument.
And was one of those arguments also that providers are leaving the state because they can't make money, so no one's going to be here to provide insurance, so less competition means higher premiums? Were those arguments presented in Florida as well?
Absolutely. And the Florida market is just slightly different than the Georgia market in that they have more claims for homeowners insurance due to climate change and all of that. In Georgia, 89% of our claims are auto related. Of course, we still have homeowners policies and all the other, but most of the claims are driven through the auto policies. But it's still the same insurance companies. It's still the same 10 insurance companies across the country that own all these affiliates and provide the policies.
All right. Thank you. I see no further questions.
Thank you, Mr. Chairman.
All right. That is the conclusion of the witnesses who wish to testify in opposition. I'm going to take just about a short 5-minute break here, and then we'll get started on those in support of the legislation. So don't go too far. We'll get started shortly. If y'all want to kind of ramble on back in, we'll try to get back underway here. All right, is it Fairvier? You are, John. If you'll come on up here, I'll toggle you on over there. And just get started when you're ready.
Ready? I'm going to take this 10-minute speech and cut it down to 4 for you real quick here. Mr. Chairman, members of the committee, thank you for allowing me to speak today. I also want to thank Senator Kennedy for bringing forth this much-needed legislation. And also I want to thank Governor Kemp, Lieutenant Governor Jones, and Speaker of the House for their leadership and support for this legislation. My name is John Fairvier. Some of you might know me from other duties I perform for the state in this very room. But today I'm here to speak on behalf of Waffle House. I am the Vice President of Risk Management and Security for Waffle House. I have been employed by Waffle House for 36 years, 7 months, and 6 days. And have been involved with risk management to the point. And I've been involved with risk management and security at Waffle House since February of 1996. A lot has happened in my career at Waffle House, but most of the significant issues I deal with are related to security and insurance type things. The cost of risk at Waffle House has gone up dramatically, and it has nothing to do with the way that we do business. We continue to do business as we always have. We serve waffles and eggs and bacon and hash browns, and we've been doing that since I joined in 1988. What's changed is the cost of insurance and the cost of Waffle House to address negligent security lawsuits. We at Waffle House fully understand the reality of what's happening to crime in America. You know, we deal with it. I know that other retail companies, I know what they do to protect their businesses, and I can tell you that nobody does more than Waffle House does to protect ours. We use CCTV with audio and visual. We have signage. We have walk-up windows. We have automatic door locks. We have fencing, lighting. We use environmental design. We have training. We have policies and procedures. We use de-escalation tactics. We use live guards, and we use remote guard monitoring where necessary. And I want to tell you right now that if this bill gets passed, we will not terminate any police officers or any guards or remove any security that we put in place. Florida and Mississippi have passed legislation, tort reform legislation. We increase security in both those states afterwards. We continue to increase security. There's nothing more important to Waffle House than the safety and security of our customers and our associates. This bill does not eliminate incentives to create safe environments. All good businesses want a safe environment, and they will do what's necessary to create that safe environment for their customers and associates. I want to talk a little bit what's happened to insurance costs for us in the last 6 years. In those last 6 years, Waffle Houses, we've increased the number of restaurants by about almost 15%, but our insurance has increased by 234% in the last 6 years. Additionally, we've had to increase our self-insured retention so that the first $750,000 of every claim is paid by Waffle House, not by an insurance company, but by Waffle House. We are often forced to settle by the insurance companies within that limit. They call it the hammer clause. I'm sure you're familiar with that. But those dollars come directly from us. Every case that we have to defend is a loss for Waffle House, whether we win in court or not, because we're spending the money, that first $750,000, and you know defense costs aren't cheap. These costs are ultimately borne by every customer of Waffle House, many that are in this room today. Waffle House, like all food retail, is a low margin business, you know. We have to sell millions of additional waffles just to cover the cost increase for the insurance. Millions of additional Waffle Houses. That doesn't include the millions in additional costs that we spend to protect our properties with security measures. I know I'm in 4 minutes. I want to tell you about one story, though, because you've heard of, we've heard a lot of stories. We had a case that recently happened at a Waffle House here in Atlanta where a gentleman came in and ate with us, had a good meal, walked off the property, and was shot off the property. There was a roving gang shooting that happened about 40 minutes prior, far away. They pulled on to a property adjacent to us. We sat in a strip center. We had our own property and a parking lot. The shooting took place, happened on adjacent property. The gentleman who ate with us was on adjacent property at the time, yet we get sued. We had an armed guard in the parking lot at the time. We had all the other security measures that we had talked about, yet we get sued, and we were forced to settle within our limits of $750,000 in order to retain our insurance. Now tell me how that's the responsibility of Waffle House for something that doesn't happen on our property that we had absolutely nothing to do with. That's the kind of things that happen, and that's not a single incident. Those happen all the time. This bill isn't about protecting irresponsible actors or irresponsible companies. This bill is about protecting those of us that do the right thing. That's what this bill does. Juries and judges still have the discretion, as they always have, to punish the wrongdoers. And I'll make one last quick point. Waffle House operates in 25 states. 20% of our restaurants are in Georgia. 83% of our legal costs are in Georgia. Georgia costs 10 times more than Texas, 21 times more than Tennessee, 21 times more than South Carolina, 27 times more than Alabama, and 89 times more than North Carolina. Costs like that negatively affect Waffle House's long-term growth strategy. Once again, thank you for allowing me to speak. I feel like this bill creates the right balance to protect both Georgia's citizens' constitutional right and also bringing justice for those of us that try to do the right thing.
Thank you. And what was that, hold on here, a question or two. What was that statistic? You said 83% of the legal costs are in Georgia, but how many?
20% of our restaurants are in
20% of
Georgia.
your stores.
83% of our legal costs happen in Georgia.
Chair Lady Miller has a question.
Thank you, Mr. Chairman. Just a couple questions for you. Thank you for coming. I am a big fan of Waffle House. I just want to understand the statistics. So 20% of your stores are in Georgia, 80% of your legal costs are in Georgia. What is in that legal cost number?
That's defense of negligence claims or the type of stuff we're talking about today.
So is that solely, is your sole 80% of your legal costs in Georgia are solely premises liability, negligent security cases? Is that your testimony?
Well, premises liability, negligent security, negligent hiring and retention, they all come in the same type of, when we get sued for multiple things. But the 83% is the total, it's 83% of the total legal costs that we spend in Georgia.
Okay, but I just want to drill down though so what about employment cases?
It doesn't include employment cases.
So that your employment lawsuits are not in that 80%?
That's correct.
Wage and hour?
No.
That's not in the 80%?
Not workers' comp, no.
No, not workers' comp, but just like wage.
No.
Have there been complaints filed against Waffle House for unfair wage cases or unfair worker practices? Are any of those cases pending?
That's not in my purview. I can't really answer questions about that. So.
Okay, so but this legal costs for 80%, you're saying that is only negligence-related cases?
General liability-related cases, yes.
General liability-related
yes.
cases. Okay, understood. And then my other question for you was really one to understand. You said that you're a good business and that you will increase security and you will not stop security, and I don't doubt that about Waffle House because Waffle House is a good business. But my question to you is that not every business is like Waffle House. That's true, right?
Well, we're not here to protect the bad actors. There are bad actors out there.
Correct.
But this bill doesn't prevent the bad actors from being sued.
Well, there was just a ton of testimony here, and I'm not sure if you were in the room to hear about all the practitioners who say that under this legislation, it would essentially eradicate a customer or a citizen or a crime victim's ability to sue for negligent security. And I guess I'd like to ask you, if you think that that's not true, can you give us a factual scenario of a case that would prevail under this current bill as drafted?
Well, when you go to court, the judges and juries are the ones that make the decisions, and the judges and juries will hear the facts from both sides. And they have the law in front of them. I can't imagine where there wouldn't be successful cases where you have a bad actor. We've heard a lot of cases today where, you know, you had some really bad issues at hotels and apartment complexes.
No, I guess, but no,
Yeah.
true. That's my point. And I guess my question to you is, since you're saying that this bill, your testimony is that this bill would not prevent victims or people from going after bad actors, I'm asking you for a factual scenario under which a negligent security case could be sustained in Georgia under this bill.
Well, I'd say thankfully I'm not an attorney, so I can't really answer that. I'm here to talk about Waffle House and how this affects Waffle House, so I can't really discuss, you know, legal issues. That's not under my education. How about that?
Understood. Thank you, sir.
Okay.
Thank you, Mr. Chairman. Thank you for being here. Also a big fan of Waffle House. Both my children, it's like the first day of school, like we take pictures the first time they get scattered, smothered, and covered. So thank you. Appreciate what you do. Wanted to set a baseline there that I love y'all. But I also want to set a baseline for what you believe should be the protections of citizens in this state. And I think based on what you were saying with the investment that y'all make in security, you agree that we shouldn't just rely on the police department to keep premises safe. Y'all have some responsibility to your customers to make sure that it is a secure environment. You would agree with that?
Well, I believe that businesses have a responsibility to take reasonable efforts to secure their property.
And if they don't, do you believe that they should be held accountable?
Well, I think it would depend on the circumstances.
But you agree that they should take reasonable steps to keep their customers safe, but you don't agree that if they don't take reasonable steps, that they should be held accountable?
Well, I think that the reasonable steps depend on the business itself and circumstances. What's reasonable for Waffle House may not be reasonable for a trucking company or somebody else. So we have to take reasonable steps based on what our circumstances are and what our exposure is.
But if you agree there is some baseline, some reasonable standard of care that you should provide to customers, and if you didn't, if there was a mistake made, Waffle House should be held liable for that. Would you agree with that? If you did if we could agree on this, what's reasonable, let's pretend we do, and you don't meet that standard, you should be held accountable.
Well, I can't imagine a situation where Waffle House would be unreasonable in what the steps that they've taken. Other businesses would have to speak for themselves on that, but we take all reasonable steps to protect our premises and always will.
And if you didn't, you should be held accountable for that, shouldn't you?
Well, if we didn't, we should, but we do take all reasonable steps.
Understood. Thank you.
Thank you. Chairman Newton.
Thank you, Mr. Chairman. I appreciate what you all do, and you described several things. I do know we did talk about insurance costs a few minutes ago with an earlier speaker. Would you say that you mentioned this 20% of your stores and 83% of your legal costs, and then a $750,000 like deductible before your secondary insurance kicks in? Is that legal cost, the 83%? Is that the premiums for the secondary insurance plus all the payouts you have to do if you don't want to get canceled? You mentioned something.
No, that's Waffle House money. That 83% is Waffle House money. That's within their first $750,000 self-insured retention. And
you mentioned if you didn't settle because of the risk, your secondary insurance, your surplus lines or whatever might cancel you.
Well, there's usually a provision in an insurance policy or contract that's called a hammer clause that says if you can settle within your self-insured retention and you refuse to do so, then the insurance company may not abide by the insurance policy, may not offer coverage.
So you have to offer that, and if it's accepted, then you've paid out $750,000, or plus defense costs or whatever.
Right.
Okay. So, but if there was a broken lock or something like that, those physical things that if you had done anything wrong, once again, all these cases we're talking about today aren't the floor caved in or the chair broke when I sat in it or somebody spilled hot grease, on a customer. These are just about third parties who come on your property and commit a crime. Isn't that right?
That's correct.
Okay. So, and even in your case that you've described, it wasn't even on your property by the time the crime happened.
That's correct.
Neither of them were on your side. That is shocking that we have gotten to that in Georgia, and then you have to be forced to settle it for fear of being canceled by your insurance company or they leave the state.
That's correct. It's one of many cases. So,
thank you for being here, sir.
I have another question. What Park?
Thank you, Mr. Chairman. I'm also a fan of Waffle House, for the record. You stated you're not an attorney. If you heard from attorneys on all sides of this issue that this would eliminate protections and the opportunity for sex trafficking victims to seek justice, would you be open to an amendment? Would Waffle House be open to an amendment?
Well, I couldn't speak to that. I'm not the sponsor of this bill or the writer of the bill. I'm simply here to testify on behalf of Waffle House and what our experience has been.
Certainly, we have a letter from the Gwinnett Chamber of Commerce that says that they welcome language that would add further protections for survivors of sex trafficking. With Waffle House being such a good corporate citizen here in the state of Georgia, I hope, if Waffle House is authorized to allow you to speak on their behalf, that again you would be open to certain amendments that would again ensure that victims of sex trafficking, minors and elders subject to abuse, that some of these new provisions would not apply. But if you can't speak to that, that's fine. I had one additional question, Mr. Chairman. Language on lines 225 to 228 continue to give me a lot of heartache and concern. We had prior testimony saying that this would essentially incentivize a race to the bottom. This is with respect to how you are maintaining your premises, such that essentially if it's substantially greater than the general risk of wrongful conduct in the vicinity of the premises. My understanding as I read this language is that, again, if you have a business, your level of liability to a certain degree is dependent on the vicinity around you. And which, again, if we're saying that you're not going to be liable, so long as you're just a little bit better than those around you, how does that not result, especially when we're from a business perspective looking at cost savings, how does that not result in a race to the bottom of the barrel with respect to protecting premises?
I don't see a race to the bottom of the barrel. I mean, we are aware of what happens around our restaurants, but a lot of what happens around our restaurants doesn't affect our restaurants, and so sometimes we'll be associated with, for lack of a better example, an apartment complex that's a half a mile away, that all the incidents are happening in the apartment complex but aren't happening on Waffle House property, have nothing to do with Waffle House, and why would we be responsible for that? But at the same time, like I said, all good businesses want to protect their customers and associates, and we spend whatever's necessary to do that, to protect our customers and associates. You're going to have some bad businesses, and those bad businesses are still going to be punished. They're still going to be able to take them to court and get justice there. This bill protects those of us that are trying to do things right, which is the vast majority of businesses in the state of Georgia, the vast majority of people in Georgia. And right now, it just levels the playing field for us.
I would agree with you. I think there's certainly bipartisan intent to ensure that we are not hurting our good businesses. But again, given in light of the prior testimony, I think we have to also be very mindful that we're also not limiting access to justice to the most vulnerable. And certainly, again, there's a long history of bipartisan support for sex trafficking, to eliminate sex trafficking here in the state. And to hear such strong testimony based on the language of this bill of how it would eliminate those protections, again, gives me and hopefully other members here in this body a lot of concern. And hopefully, again, Waffle House will be very clear in their position that as to whether or not they would be open to amendment to, again, ensure that we are protecting victims of some of the worst abuses that we've seen. Thank you.
I will have one or two other questions. Representative Williams.
Thank you, Mr. Chairman. I'm a layperson, I'm not a lawyer, but my question cries out for an answer after you made some comparisons to your insurance costs. You're in 28 states, did you say?
25.
25, and you said 89, was it 80-some% higher in Georgia than it is in other states? Or
No. What I said was that we're in 25 states. 83% of our
of your 83% of your costs
are in Georgia.
In
for
Georgia.
20% of our restaurants.
Okay, from in another life being a productivity consultant, what percent of your expense sheet is attributed to insurance cost?
I do not know the answer to that.
I think it's very vital. I really do, because we're talking about the huge costs here in Georgia. And I want to know how it impacts your bottom line, so I need to know what your percentages are, and I'd like to know the comparison statewide as to your cost of insurance. And if you could get that to me, sir, as soon as you can, since you're not ready today, I'd certainly appreciate it.
All right, Representative Williams, Chair Lady Miller.
Really quick follow-up, Mr. Chairman, to something the gentleman said in response to Dr. Newton's question. I had it in my head, I lost it. Oh, the hammer clause. So as I understand it, I just want to make sure I understand this hammer clause that you are being subjected to by your insurance provider. That clause says that if you fail to settle a case, so with any case, a frivolous case, a case that has no merit, or is it the failure to settle a case that should be settled that puts you in jeopardy of losing your insurance? What's the language in that hammer clause that qualifies the failure to settle a case?
Well, I don't have the language with me right now. There's hammer clauses in there that say that if you have an opportunity to resolve that case within your self-insured retention and fail to do so, then they can
they won't cover the excess.
Yeah, they cannot offer the coverage. So
no, I understand, but most of these types of clauses have some qualification. They're not telling you to settle every frivolous case. They're telling you to settle cases that might expose them to liability above your deductible. In other words, they want to encourage businesses who have that deductible or self-insured portion that they have to cover to evaluate the strength of the case. And if it is reasonable and prudent to settle it, they want to encourage you to do that so that it doesn't then get into what I would just call your overage insurance. Isn't that, as doing this for 30 years, isn't that usually how those goes?
Not necessarily. The case that I just referred to today was a perfect example of where we were forced to settle within our self-insured retention, even though the facts were on our side. If we had gone to court, we feel like we'd have won that case.
Okay, and can you, where was that case?
It was in the Atlanta area.
Where? Which Waffle House?
It was in the city of South Fulton.
City of South Fulton,
Yes.
And when did this incident happen?
I don't have the date in front of me.
Was it this year, last year, 2 years ago?
It was a couple years ago.
A couple years ago in
Yep.
City of South Fulton?
Pardon me?
A couple years ago in the City of South Fulton?
Yes.
If we want to define that case, is there a case number that we could refer ourselves to so that we could better understand the facts of that case?
I'm sure you could.
Can you tell us the information that might help us do
I don't
that?
have that in front of me today.
Okay, do you have the store number or the plaintiff's number?
I
Name?
don't have it in front of me here.
Okay,
I
can you
don't
get
think
it
he's
and
got that
can you
information.
get it and give it to us? Is that possible? Could you forward that to us so that we could better understand the insurance company's practices?
If the witness can get that information, that would, I think, be useful. But I don't necessarily want to have him disclose their claims history. I think the point he was trying to make is, if the insurance company tells you you got to settle it, or else they're not going to cover the excess, you got to settle it, and they're not going to cover the excess.
That's correct.
And so, I think we've got one other question down for Chairman Parrish.
Mr. Chairman, this is a question from a non-lawyer. If we've got people who are willing to come and give testimony to us, I don't feel like we ought to be cross-examining them when they want to give us information.
Well, your comment is duly noted, Mr. Chairman. Representative Evans, you have a question?
Yes, Mr. Chairman, it might be to you. You were saying that a hammer clause says if you don't settle and the case goes above the excess, then they're telling the company that they would be responsible for it. But if it's a frivolous case and no one believes it's going to go above the excess and they win, they're not going to owe anything. Were we tete-a-tete on that?
I don't know. I suppose I didn't sense that the witness really understood the intricacies of the hammer clause. He just knew there was this thing out there that meant he sometimes was compelled to settle cases when he didn't feel like he really needed to. And it may be that there was a different view of the validity or nature of the case by different people than the witness. So.
And I respect all my chairmen very much. And I don't know any other way to probe and make sure that we're getting the truth from all witnesses rather than to ask questions. And I know not speaking for anybody else on this committee, but I know the difference between cross-examination and questioning of witnesses. And I feel like my job on behalf of my constituents is to seek the truth from witnesses that come in here, because that's how I'm going to make my decision how to vote. And if I don't probe and ask questions, we might not ever find out the truth, that the person that knows the truth is not listening and come in like Mr. Rafi to talk about that case that we were all led to believe was so frivolous, but in fact was a frivolous defense. Unless he was listening, I couldn't have elicited that. So when I feel like I can get to the truth, I will ask questions, because I think it's my right and my obligation to sit in the seat that only 180 of us get to sit in.
Well, thank you, and I appreciate that sentiment. I don't believe we have any further questions for this witness, so I will thank you. We don't, I think, agree all on the legislation, but it sounds like everybody agrees Waffle House is a great place to eat, so thank you. Mike Iverson.
Good afternoon, everyone. My name's Mike Iverson. I am a past president of the Independent Insurance Agents Association of Georgia. We don't work for insurance companies, but we do work with business owners and individuals to try to help negotiate the best terms. And today I think there's been lots of confusion about how insurance works. And so I just want to start off with one very basic fundamental fact. It's an agreement. So we have statutory coverages like workers' compensation and personal auto. Those are written by the state and mandated by the state. Almost all of our business liabilities are agreements between an insurance company to say, hey, we will accept your liability in these specific circumstances for these types of losses. It's an agreement between those parties to transfer. It's not mandated. Insurance companies, and we represent nearly every company in existence in Georgia, these are negotiations to be had on whether that company finds that company favorable enough to take that risk. And so I feel like there's some confusion there, and there's been this massive disruption in the marketplace. And so I think we have to backstep and say, so what causes this disruption? Because I've been at this for over 30 years, right? And I got to tell you, the first 27 or 26, man, it's a ton of fun in Georgia. I've loved doing what I do in Georgia. I mean, for those who will demonize the industry, I will counter it with at least 15 times where I've seen people made whole after losses, and I've seen victims rightfully be paid. That transfer of risk is valuable to all parties. So what is breaking down where there's such animosity? Well, let's start with the CVS ruling. And I'm not an attorney, so you can grill me 6 ways to Sunday. I'm not going to understand all the nuances, but what I do understand is the words I've read, and I do understand the impact I have seen. And so I'm going to start with inside of the affirming ruling with Justice McMillan, who wrote about the shift in the bright line standard. The bright line standard that shifted in Georgia off that ruling. The wording was, it has been the law for over 25 years, and during that time period, the legislature has not seen fit to change that standard. To what extent and under what circumstances proprietors should be held liable for third-party criminal acts are decisions best left to the legislator, okay, which can consider the policy and practical implications, especially in high crime areas, of increasing such liability and the cost of doing business. LaGrua would concur with this, and then also write further. These cases present a challenging issue regarding the scope of a proprietor's liability to invitees when the criminal conduct of a third party, and by the way, I think we have all witnessed lots of evil be talked about today. There's evil in this world that enters properties, right? And so she says in this, the criminal conduct of a third party causes injuries to said invitees. I write separately because I'm concerned about the impact these laws have on those who reside in such high crime areas and who would face the harsh and mounting reality that businesses faced with an increased exposure to liability because of the very area for which they have chosen to do business will cease operations or raise their prices to offset the costs of additional security measures. And I wonder how these forced business decisions will impact the residents who will lose ready access to the resources they need for daily life because they are no longer available or affordable. LaGrua would go on and say, I urge the Assembly to consider these issues as they institute laws imposing premises liability on the state of Georgia. And so other justices would agree with this concurrence. And so here we stand in an environment where I'm confused by this because I know how many times I've gone with businesses who struggle with insurance needs and struggle to find the terms and conditions they want. And I'm left saying, what are we faced with? Insurance companies. You can argue about their profitability, and yet the logic of them being unprofitable, so if you say they're unprofitable, then they should be writing less insurance in Georgia, which they are. If they were wildly profitable, well, then you'd see them wanting to write more policies in Georgia. But we're not seeing it. What I'm seeing, and what my 5,000 compadres who sell insurance all throughout Georgia are seeing, is obviously rate increases. We're seeing new exclusions. I mean, I got news for you. An insurance company just gets to say, you know what, we don't want to defend assault and battery cases anymore. We aren't going to insure it. We're going to exclude firearms. Anything that involved a weapon of any sort, we're going to exclude. We don't know how to handle the Georgia market any longer. That's what I see every day from my business owners. So what are you asking business to do? You're asking business owners to shoulder all of the responsibility. We have a crime problem. There is no doubt we have a crime problem in Georgia. But if you want to put all, and by the way, we can look at some cases where there are huge liabilities, greater liabilities placed on the business than there was the shooter. To me, that's an inequity that needs to be in balance. And there are problems there. And when I look at who's impacted, here's the things that's missing here. Right across the street, you guys want to walk over, I'll take you over, because I got involved in one of their insurance issues, is the Bashore Men's Shelter. Do you know what they do? They house 100 men every night. And they can tell you how many are going to die the nights that they aren't open in the middle of the winter. And they can tell you that, guess what? Under these standards of reasonably foreseeable and totality of circumstance, the new standard that comes out of the CVS case, you want to tell me what could happen in that shelter that wouldn't be reasonably foreseeable? There is nothing that couldn't happen that wouldn't meet that definition of reasonably foreseeable. Their pursuit is noble. But behind that group is a bunch of people who, many of them, have said, you know what, this is my purpose. They've invested huge dollars into this charity to do these things. And what we've told them is, well, we're going to sue you because this happened in your shelter. And by the way, right across from the state capitol, they intervened one night for a young lady who was raped 20 times by 20 different homeless men. Young girl, 18 years old, with a 6-month-old baby. That's adjacent to this property. And so what I'm saying is to think that this doesn't have an impact on the not-for-profits. I think of the group that I work with that works with developmentally disabled children. I think of groups, churches. I think of a church that's sued for a death in their cemetery after hours, and I'm pretty sure they weren't there to visit a deceased relative. I think of all sorts of different situations. I think of clients I have who have been sued because they owned a laundromat where one customer tripped over the other customer's 2-year-old, and the laundromat was left to pay. So Georgians are crying out, and by the way, the Assembly has cried out. And I think that when you look at the day on the Capitol, I haven't seen anything like it. There's a need, there's an issue, and at some point, this group needs to answer that call. And I'm not asking you to do something that is easy. We're asking you to do something that's right, because there are many good business owners, many more good business owners than there are bad ones. And this isn't about insurance. It's about one of the greatest vehicles that's existed in our country, which is allowed, by the way, John Deere. Everybody knows the brand John Deere. John Deere started out as a guy who was a blacksmith and had 2 fires. That would have been the end of John Deere. The first one would have been, were it not for insurance. And so insurance protects small businesses, and it's our small businesses who are being disproportionately impacted, especially all of our charities, non-for-profits, churches, anybody in any area where crime has come to their community.
Thank you, sir. You've got a few questions. Representative Evans, I think you were first on board.
Thank you, Mr. Chairman. Thank you for being here. I think there's probably a lot about the legislation that we, or about policy that we don't agree on, but I think there's probably a couple things we do, and I just want to see if I'm right. Insurance exists to bear transfer risk in some way. I mean, that's the whole point, risk management, right?
It's transfer of risk.
And no insurance company would expect to not pay out some claims. That's why they're there, right?
I think every insurance company, when they write a contract and they have specific types of risks that they're going to cover, that's the agreement that they've struck. And so if those terms and conditions are met, that's what you would expect to be paid out.
Right. I mean, that's not aberrant that claims have to be paid is sort of my point. I just want to make sure we agree on that.
Okay.
Do we? I mean,
Yeah,
it's not aberrant to pay claims.
I mean, I fight all the time. I mean,
Right.
That's what we do with our
Sure.
clients is we make sure that their contract actually covers the exposures that they have and want to have covered.
And I think you said you were not a lawyer, and I'm only asking you this question about Justice McMillan's opinion because you brought it up. She talked about perhaps, or LaGrue, I can't remember, but the need to balance, and the legislature should consider the effect on businesses and that some businesses may close, I think was sort of a summary.
It was LaGrue, but the other justices did concur, yeah.
Right. Would you agree with me that there are some businesses in this state, some apartment complexes perhaps owned by out-of-state interests, some motels that are flagrantly supporting sex trafficking? We would be okay if they close. I mean, not every business needs to stay open. Not every business is good. Do we agree on that?
I think that the gentleman who testified early, very passionately, I would agree with him, who said we all have to step up. These are our communities, and we all have to care.
And if a company's not doing that, we're okay if they don't stay open.
Yeah, I think there's a fine line in understanding what that is. And
Sure.
I think that all business owners are crying out because right now, what is enough? What is enough? And I think that's a very confusing moment for business.
Thank you.
Thank you. Chairman Newton.
Thank you, Mr. Chairman. You mentioned a couple of different things, and I know you mentioned a bright line and how the first 27 years of the last 30 were one way, and now things seem to be evolving differently. In your opinion, does Senate Bill 68, in particular this premises section on negligent security, which I think occurs when a criminal comes onto or near someone's property and commits a crime, you mentioned firearm related or assault and battery, so is your understanding this section 6 is to give the business owner, when that criminal comes on a property and commits a crime against another person, that the goal of this and the result of this is to give some guardrails and some predictability to both those hopefully providing insurance so they can stay in business, but also to the business owner, the tenant, whoever's working there. Is that the goal, you think?
Yeah, I very much believe, and I'm thankful for a bill that brings on the concepts of let's address what is reasonable. I mean, those were the actual statements from the Georgia Supreme Court justices, is that these things are left open and they haven't been answered, which I believe is the call of the assembly to answer those questions.
And that appears to be
so
the goal
do
of
they.
this legislation.
Yes.
Right. Okay. Thank you, sir.
Thank you. Representative Miller.
Thank you, Mr. Chairman. I just wanted to ask you a couple questions. You said you're not a lawyer. I'm not an insurance person, so I'm going to ask you some questions about insurance to help me understand. So you said that insurance is essentially, in and of itself, just a contract between two parties.
It is.
Yes.
In fact, it's a unilateral contract generally.
Unilateral contract. Explain what that means.
Unilateral is usually designed by one party, and it means that the gray areas usually fall to the benefit of the other party. I've taken advantage of that one many times.
Okay. So then, but I guess insurance is a little bit different from just, say, two people going into a contract, and that is evidenced by the degree of regulation of the insurance industry, right?
Yeah, and I think this was referenced earlier, which is a really good one. I mean, the thing that I've enjoyed most about being in the Georgia market, because I came here from another state, is how well the state has done regulating its insurance markets. I mean, we've had a very healthy and vibrant market until recent years.
And so would you also agree with me then that many of the arguments and statements about what's going on with insurance premiums were made in Florida not too long ago? Similar things, same sort of arguments.
Yeah. Well, here's what's interesting. I mean, crime is a problem everywhere, but that doesn't mean that every crime is the same everywhere. There are different crimes in other areas, and so when you're trying to compare Florida, and so this was just one of those things that I find fascinating that came up this morning, because I'm like, wow, there's just this missing piece for people to understand the differences between Florida and Georgia. Let's go through the history of Florida. Florida really came out of a wind-prone problem in the early 90s. They got hit by massive hurricanes, and it created this deficit in insurance. What grew out of that deficit in insurance, because carriers also said, geez, you also have this growing tort issue. And so you did see a bunch of carriers start to pull out of Florida, so much so that their state fair plan filled up. Number one writer in the state for multiple years in a row was their state fair plan. So what did they do in Florida? Because that state fair plan was insolvent. Insolvent. If the wind blew, those citizens would have been left with nothing, and we would have needed a FEMA bailout. So what do? They incentivized domestic insurance companies to be started inside of Florida. So you have the birth of all these domestics. And they said, hey, as long as you're 20% more, we'll let you start up an insurance company, and we'll sell off these policies to those small domestics. So they're not AM Best rated. Earlier, the gentleman said all the top writers. These were insolvent carriers who were financially weak. They were desperate because of the marketplace that they had. And so those are very different. And then they developed an entire different system. It's called an MGA strategy in Florida. And so then these companies wanted to expand, and so you have the whole problem of solvency, and the mandate's on at 4.5%. So I'm very familiar with the issue. I know that Georgia is not Florida, and I don't want it to be. And the point of keeping the market healthy is to keep us from dealing with issues like Florida is right now 30 years later.
No, and thank you for that. But I guess my question was a little bit different. The proponents of this bill and the folks who have supported it have pointed to Florida as an example for why we should also do tort reform. That's what I'm getting at. And then
I think from a tort standpoint, I think there's a lot of truth there in Florida.
Okay. And then, but what we know right now is that in Florida, there's currently an investigation being conducted into the insurance industry. Essentially, what I understand of it is that during the tort reform debate in Florida, the insurance industry was claiming things very similar to what we're hearing now, that it's not profitable, we're not making money, we're taking losses, we're going to flee. And that while that was going on, these same insurance companies were essentially doing some very creative, I guess, accounting practices. I don't want to go into the details about that.
Let me give you this, because I think you're on it, and I would encourage you to dig even further into who the bad actors are, because you're almost isolated all to Florida domestic insurance companies who are providing property coverage in Florida, who are trying to expand out of Florida. And so their problem has been not having the big AM Best rated carriers of the world. In fact, Florida came up with their own rating system because they couldn't get AM Best rated insurers into the state. So they came up with their own rating system for these small, unviable ones. And almost everyone cited, at least everyone that I've seen cited, because I've been keeping up on some of the Florida issues. They are Florida domestic insurers who spawned up out of taking coverage out of their wind pool, which was Citizens, and writing some of that exposure. That sort of inducement, when your state fair plan is the number one writer in the state, it's a recipe for disaster.
That's fascinating. Thank you for sharing that. And I didn't realize that was a perspective. So I guess what you're saying to a non-insurance person right now is that the problem in Florida is solely related to, or the things they're investigating are solely related to these new homegrown domestic insurance.
They've had a host
industries.
Of these thinly financed companies who started up during the vacuum of coverage, who've gone out of business, and that actually helped raise the bell, because they're like, where did some of this money that you had reported go? and they pulled those monies out of state.
Okay, not any of the big national insurance companies that do business here in Georgia, though. They would not be involved in this investigation that's going on in Florida.
I have yet to see a report that cites it.
Okay.
And I don't see the same vehicle that operates inside of Georgia that operates inside of Florida. I mean, the way insurance is sold in Florida is different than Georgia, the way that it's sold. Doesn't mean that we don't have tort issues that we can share. Those two things can also be true at the same time.
Thank you. What part?
Thank you, Mr. Chairman. Had a few questions over here. Had a few questions. Also wanted to just say thank you for reminding legislators that it's ultimately our responsibility to determine that and to strike that correct balance that ensures we have a healthy insurance marketplace. Is it not true that before the Affordable Care Act that private insurance companies denied individuals with pre-existing conditions coverage?
First, I will say this. I'm not a health insurance guy, but I know some about health insurance because I was part of the market at that time. On an individual basis, there was underwriting of policies that could allow for it. On a group basis, there was not.
So, I mean, I think the point is, it's not a irregular occurrence for the legislature to come in and demand insurance companies to cover some aspects that they would otherwise exclude. Is that correct?
I think you can look to our friends in California and ask them how well it's gone, because what's happened there is really been a legislator that convinced insurance companies to stay when they knew disaster was coming. And so what's really tough is, for California in particular, is their state FAIR plan again. Here's another one of your signs. When that state FAIR plan starts to grow, which California has seen their state FAIR plans start to grow, it means carriers are starting to evacuate the marketplace. So consumers are getting worse coverage at more premium. And now the state, those who are the biggest losers, were the ones that everybody in California convinced to stay behind. So the legislator said, please stay here, don't leave our market. We're going to do something eventually, but they didn't take the action. And what would happen out of it is some of the worst losses insurance carriers have ever had. And guess what? They just made the CEOs who said, get out of California now, the brightest people in the nation, because they protected their policyholders from insolvency.
Now, again, with respect to finding that right balance, again, I remain very concerned as I read through some of these provisions of how it would likely deny victims of sex trafficking and other victims, especially the elderly and children, the ability to pursue justice, especially if we're increasing the standard to, for example, a subjective determination of the property owner. Do you think that goes too far?
I think that currently the standards that are being used in cases in Georgia does go too far. I mean, otherwise I don't think the justices would have called for a change. And then in addition to that, do I think there are some really good operators who are great people, who are demonized for things in order to maximize a claim? Yeah, that does happen too. I mean, but in the end, remember that this is an ecosystem. It's a balance. If a policy has no coverage, so they completely exclude assault and battery, and then we have an assault and battery. I mean, I hope you're talking about solvent properties that have a lot of equity in them and a lot of cash on their balance sheets, because they don't have anybody giving them a financial guarantee to help a claimant.
Right. I think specifically my question, is related to line 174, where they're saying the particularized warning of imminent wrongful conduct by a third person requires that the owner deems it credible, right? So essentially an owner has a subjective ability to determine whether or not they are otherwise liable. Does that not go too far? As proposed by this legislation.
I think we can say that one's tough, because here's the other side of this. I know it from my own firm. I know I have one lady who I completely adore in my firm, and she always feels unsafe. I mean, she'll tell you anywhere she goes, she feels unsafe. And she's told me about whether it's, and we live in an area that we consciously chose because we knew it was an engaged community that would look out for each other. And so we live in a community that I just, I don't want to minimize her feelings, because sometimes feelings rule, but she does feel unsafe anywhere she goes. So do I look at that and have to give it some credibility against what other employees tell me? Yeah, I do.
Would you at least agree that perhaps some additional work could be used to ensure that this legislation strikes the right balance so that, again, we're not continuing to litigate this before the Supreme Court, but that as legislators, we are doing what we can, given all the testimony that we've heard, to strike the right balance? Would you agree with that statement?
I think balance is always good. However, I do think that this issue has been in front of the legislature for a period of time, and I know our governor has taken a very thoughtful approach. This is not a new issue. I mean, I know some of you from testifying last year because I had great concerns, and I said, look at all the filings from insurance companies. They're getting ready to use these. And I saw it coming. And so I had concerns. I felt the ecosystem was in jeopardy. And at that time, we wanted some action. And I feel like the governor's done a wonderful job of finding a very measured approach.
Last question, if I may. I'm not an insurance person either. So help me understand, insurance companies, they, had an underwriting loss, yet overall they made a $90 billion profit.
Yeah.
Why is that profit not also shared with consumers? Why does that not go to help lower the costs of Georgians?
Yeah, fantastic question. I mean, really great question. So I'm going to do a compare and contrast because the numbers you cited were national numbers, okay? So when we go to Georgia, I'm just going to look to multi-line peril. And by the way, all this data is available. And earlier, I don't know why people haven't been able to get their hands on it, but we can certainly share data from the National Association of Insurance Commissioners as well as others. But if you just look at the multi-line peril policies, which in Georgia, most small businesses are buying multi-line peril policies, right? It's kind of this inexpensive policy, business owner's policy that gives a little bit of property coverage, gives a little bit of liability coverage, does it all in one. It makes up about $1.5 billion, 1.6 and some change in premiums. Insurance companies in Georgia lost a little over $500 million in 2023. Now, insurance is complex because they get two things, right? They get to hold the premiums until those claims are paid, and they're going to try to earn some interest off it. That has to stay very liquid, and so usually it's invested in bonds or something else that may be a 3% return, and then they have surplus, statutory surplus. This is California's problem, and the reason that Florida's had problems with a bunch of these insolvent carriers that did not have the strength of surplus to cover their liabilities. It leads in consumers being hit with assessments through all the policyholders who survive. And so surplus, we call it a war chest. So I'm looking at an insurance company, I want to know that they have a war chest and they can survive major events. Using Georgia's example, we had $2.5 billion in the last loss, and that's out of 25 billion for that entire storm. California is up to $250 billion in one loss for their fire losses. And so that war chest also will receive interest. But the way I say it is, if I'm operating a restaurant and I spend $1.02 for every dollar I take in, am I profitable? The answer is no, I'm not running a very good business. Well, what if I have $1 million in the bank and I earn interest? Do I have a good restaurant now? No, I do not. I just happen to have savings that I was going to spend on expansion and other things. And what I know about insurance, and this sounds tough on insurance companies. I've watched insurance companies spend a dime to try to make a nickel. The industry chases when they see profit and they see anybody starting to profit, man, they chase that business in healthy environments. And we just aren't that healthy environment right now.
Thank you.
Thank you. All right, Representative Evans, let's close it out with this witness.
Very short. Thank you, Mr. Chairman. Just to repeat the chorus of I'm not an insurance person either, and I am a lawyer in real life, but I rarely am dealing in a case that has insurance, or at least that I know of. I mean, it may be there somewhere, but it's not kind of the cases we've been talking about here over the last few weeks. So I really don't understand insurance, and I think I'm getting there, and I want to make sure I'm right about this. You were talking about you can ask for an assault exclusion. You can ask for certain exclusions in policies. Those have to be approved by the insurance commissioner. That you just can't, because it is a unilateral contract for the most part, you can't say, hey, sign this, but I'm going to exclude you know, these 10 things, you've got to have permission to do that, right?
Well, there's two types of insurance companies. There's admitted, who file forms, rates, all their methodologies are followed by the insurance company, or by the insurance commissioner. They're under the insurance company's purview. And then there's something, we call it insurers of last resort. So for licensed people in my industry, there's certain protections that go to every consumer when they buy an admitted policy, right? They get some backstops through guarantee funds and other things that are established by the insurance community that operates inside of Georgia, so that people can be made whole if the company goes bankrupt. When you go to surplus, you don't have those same backstops.
But
And
some of
so,
the companies that have been here today, you know, like a Waffle House, for example, or I don't think they're here, but we've heard about
Yeah.
CBS. I'm not sure that they're here, but we've heard about Racetrack. Those companies would have the kind of policies that if you're going to exclude something like that, the insurance commissioner would have to say it's okay, right? Like assault.
in general, no, because when you get into large self-insureds,
Right, I'm not talking about self-insured wouldn't need to ask the insurance commissioner.
yeah,
And so are you saying the companies that are here,
the companies that are here do file all forms, policy forms, endorsements, rating schemes, everything else. And then they also, you know, I have one that's a really good example, because so much of what we're talking about is premises liability. This was a note to our commissioner from one insurance company who said, hey, they're a major writer of small business in Georgia. They said, we've made the decision to stop writing grocery stores, gasoline stations, liquor stores, motels, and hotels, and will non-renew all policies within the state of Georgia. And so they have that business decision. And so
that's the letter that you're reading from there?
Yeah.
Could we have a copy of that?
Yeah. In fact, it's in the Georgia SURF system, which is what's great about our state is our Department of Insurance is very, very open with all filings, forms, everything else. It's all in there.
Well, and I appreciate that, but I don't know where that is. I just want a copy of that letter that you just said. But when we're talking about it, I'm just trying, there's a lot of stuff that you said that I don't understand, but let's talk about a run-of-the-mill grocery store, gas station, maybe not a national chain, but, you know, a decent size, not a one-off. If their insurance company wants to exclude coverage for assaults, typically speaking, do they have to go to the insurance commissioner to get that permission?
If it's in their list of approved forms, it's available to use according to underwriting at whatever guidelines they wish to apply it.
And approved forms are what?
Approved forms are their forms. So admitted carriers file all their policy forms.
Like the exclusion
And they
endorsement.
also, exclusion endorsements, your homeowner's policy is a filed form with the insurance commissioner's
And
office.
so the insurance commissioner has to approve that.
Yes.
So whatever is included or not included, ultimately the insurance commissioner, if it's filed form, he's got to say in this instance yes or no.
Yes.
Are you aware of anyone in Georgia asking for permission to exclude coverage for assault?
Oh, yeah. I mean, you mean consumers or insurance companies?
Insurance companies.
Oh, yeah.
And where would I find that?
You would find that inside the Georgia SURF system. It's an open access
And I could
record
just
system.
search for.
You can do all sorts of searches.
Can you
search.
just say that? Spell it for me.
Yeah.
Georgia.
It's Georgia SURF, SERFF, which is back in the day. I mean, I used to go down to the insurance. I'm a nerd. I'm an insurance nerd. I'd go down to the insurance commissioner's office to look at files for insurance companies, and so the commissioner got tired of people like me, and so they just made an open access system where any of us can go on and see what's happening.
And has the commissioner ever said yes, that you can exclude assault coverage?
This been approved for
That you're
many
aware
years.
of?
What you have is carriers using
I
it now.
think we're making this thing, there's a form that has to be approved, and then the company can use it if the underwriting calls for it.
Yeah, that's right.
I think
And
the
there's
witness is
also-
not saying that it's got to be approved in a particular instance.
No,
It's
it's
just
not
the
in a
form has to
particular
be.
instance. It's an approved form in the state. And I'll use almost every policy you buy at the bottom of it, if you look at ISO, that ISO is Insurance Service Offices. It's Insurance Services Offices.
Okay.
ISO forms are the standard that most carriers, when they're expanding into new states, they'll start with ISO forms and then they'll figure out what the rate should be and derivate from that. But ISO also gives a lot of terminology. So you can look at, some carriers will file some of their own proprietary forms, while other carriers will say, we're just going to adopt all the forms that ISO has for us to use.
But will I find forms where an insurance company has filed this form and it will specify that we're not covering assault? We're not covering liability.
We're not covering any exclusion, firearms and weapons. Any crime that involved a firearm or a weapon.
In the insurance commissioner, I think I understand the chairman's point, is not saying, explicitly saying yes or no, but if it goes on, if it gets filed as a form, then that's technically okay. And would there be a way for the commissioner to say, no, you can't do that? If you're going to offer our businesses insurance, you can't just pick and choose what you want to cover?
No, actually, the state. So maybe the question could be, what can you do about it? Well, you could go back and say statutorily, we're going to create some laws that mandate that every business carry general liability insurance. They're not required by law to carry general liability insurance. They're required to have business auto. They're required to have workers' compensation.
Yeah, no,
But everything
I get
else
that.
is an optional item for businesses.
Everything that they cover is optional.
Property is.
But they have to file these forms.
No, the insurance company does.
I must be missing it, and I'll have to talk to you offline.
Let's
Be
see if
glad
we
to.
can.
Maybe
My
somebody, I'll phone a
understanding-
friend
look,
and figure out
I want
this
you to understand it, but also it's 6:40 and we got 4 more witnesses to go. I think the issue is the form is approved and then is approved for use by the company at its election.
Indeed.
If it determines that it doesn't feel like it can undertake a risk as an underwriting matter in a particular instance.
Yes.
So they don't then have to go back and get approval from the insurance commissioner to use the form in a particular instance. It's already been approved for use as they deem appropriate.
Give that man a round of applause. You're not going to clap for me, but well done. That's it.
All right, let's if y'all would, let's move on. We've got a few more witnesses, and I still want to let Senator Kennedy have some time at the end. So, Haley Bauer Frank. I suppose good evening would be the proper salutation at this point, Ms. Frank.
I know, I had originally good afternoon, but maybe good evening, good night, I don't know, one of those. I wanted to start off before we get started. I was very nervous to testify today. I'm more nervous now after the Waffle House exchange, and I want to just tell everyone I am not an attorney. If you ask me anything legalese, I can't speak legal on behalf of my company. I'm just truly here just to tell my story as a small business owner here in Georgia. So, but I will do my best if y'all have questions to answer at the end. So, all right, thank you, Mr. Chairman. Thank y'all so much for allowing me to tell my story about my family's small business and the importance of tort reform in our great state of Georgia. We are incredibly grateful for the leadership of Governor Kemp, Senator Kennedy, and many others in making tort reform a top priority this session. I'm also incredibly thankful for the leadership and thoughtfulness that each of you bring to the table in ensuring that meaningful reform happens. My name is Haley Bauer Frank, and I'm the Chief Marketing Officer at Clipper Petroleum. I'm also the Legislative Chairwoman for the Georgia Association of Convenience Stores. My family owns and operates Clipper Petroleum. With over 50 years of family ownership, my dad, Tom Bauer III, still serves as president with 2 of his 3 daughters, myself and my sister, Caroline Filchek, Chief Strategy Officer, working alongside him. With a commitment to continued family ownership, we continue to be dedicated to pursuing excellence in every aspect of Clipper Petroleum. We are based in Flowery Branch, Georgia, and operate 23 convenience stores in Metro Atlanta and North Georgia under the Clipper name. Clipper also provides fuel distribution to gas stations and convenience stores throughout the Southeast, including over 250 convenience stores in Georgia. Over the past several weeks, I've personally heard a lot of talk about Senate Bill 68 and that it disincentivizes store safety, but that statement can't be further from the truth. Most of us who own and operate C-stores genuinely care about the communities, customers, and team members who live, work, and shop in the areas where we conduct business, and they choose to shop with us. That means that safety is always a top priority to us. We choose to be the retailer where mothers feel safe bringing their kids after school to get snacks, or the celebratory ice cream treat that the dad or the fun aunt and uncle bring the kiddos after the big 6U baseball game win. We choose to be the retailer where families love to stop to use the restroom, to fuel up their car, and to get snacks or even a nutritious meal on the go or during a road trip. And why is it that the moms, the aunts, the uncles, the dads choose us? They choose us because we go above and beyond at our stores by providing a clean and well-lit facility, hiring the friendliest and most helpful team members, having a variety of nutritious snack and food choices to fuel their needs, and by making sure we have the cleanest restrooms in Metro Atlanta and North Georgia. We go above and beyond and provide a safe shopping experience for all that walk through our doors and provide a safe workplace for our team members. After all, our team members and our customers and our community are the cornerstones of all that we do. This isn't just the norm for the day-to-day operations at Clipper stores, but many other independent operators and other multi-store convenience store retailers in our state, our friends and peers, operate the same as we do by going above and beyond for our customers and our team members and our community. The claims and lawsuits that businesses like ours are being forced to settle is truly incredulous. Just recently, at the end of last year, there was a $1.1 million settlement at a Metro Atlanta store. This is separate and distinct from the one you've heard about previously. 2 cars with several occupants in each vehicle drove onto the property at 3:30 in the morning and parked beyond the gas pumps near the back of the canopy. The car's location was about the furthest away from the C-store that you could be and was in a non-parking area. Prior to the 2 parties arriving at the site, they apparently had an altercation beforehand. Neither party came inside to purchase any items from the store, and they never pumped fuel in either of the 2 vehicles. The members in the vehicles, 3 to 4 per car, exited their vehicles and started to physically fight on the property. After a few minutes, one party got into their vehicle to leave. A male inside the car pulled a gun and shot one of the women and the other party in the leg. By the grace of God, she survived, but they were later sued by the woman for negligent security. If you all were to see the video, it is absolutely clear that no security guard, armed or unarmed, nor any customer service representative at the store could have broken this up. There had been no criminal activity at the store previously other than petty shoplifting, like putting the Snicker bars in your pocket and walking out the door. These people never intended to purchase anything from the store. They only used the property to argue and fight and eventually shoot someone. Because of the current litigation system and the fear of what would likely be a much larger verdict, as well as the time and stress that litigation puts on small businesses, the C-store owners felt like they had no option but to settle with the woman for $1.1 million. The store had to make the unfortunate decision to pay this woman rather than go to trial, pay attorney's fees, and potentially pay a larger unjustified award, not to mention the anxiety and stress those small businesses under. Sorry, Chairman, I'm finishing up.
If you'll wrap up for me. You're about
Okay.
5.5, 6 minutes.
Okay. And these types of cases are not unusual. I'm not going to read all this because I know I've got to finish up, but this is not unusual for small business owners in the state of Georgia and for C-store owners. The risk to conduct business in Georgia is so high, insurance premiums are increasing at a drastic rate. It's preventing job growth for small businesses. We have had to close some of our 24/7 stores, as our dealer partners have as well. In many cases, insurance policies will not be written for stores that are open 24/7. While this may seem like a minor issue for businesses, there are many hardworking Georgians, first responders, and others who rely on us to fuel their day, even if their day starts when most people's day ends. The third shift worker is a vital part of our economy, and we are the ones who serve those hardworking men and women for fuel, snacks, caffeine, and groceries. I'm going to skip all this, Chairman. I'm sorry. Okay. Last thing, this may just take a minute, but let me just end and put this in perspective for each of y'all. Just recently, we had 2 back-to-back snowstorms hit our state. We all know Georgia weather, and if it snows even half an inch, the snow melts, the temperature drops at night, and ice has replaced the snow. Would you want convenience store owners to shut their doors when this type of weather situation arises? Because of the fear of frivolous lawsuits and phantom damages from slip and falls and other types of accidents, we are having to make these tough decisions. Where do we stay open or do we close? Even though we happily put out warning signs for ice, we gladly salt, put gravel out, shovel sidewalks and other areas that could be ice or may be iced over at some point. But regardless of the extra precautions we take, how can we prevent every single slip and fall? Never mind those individuals who come onto the store looking for a payday by purposely slipping. I'll end by saying that I've been very anxious about testifying before y'all today because of the risk of our businesses being targeted just from testifying. We shouldn't have to worry or be fearful to share with you all about the true pains and real stories that we are facing to do business here in Georgia, but we are. To highlight this, my family was at a fundraiser at a local nonprofit foundation in our hometown, and a local trial attorney came up to us and said, I quote, "We would really like to sue Clipper." We were dumbfounded and honestly scared. And how should a business respond to such a threat like that? I appreciate what each of y'all are doing for our great state. I've said this before and I'll say it again. Small businesses are the true backbone of our economy, and we need your help to ensure that there is balance restored to the judicial system here in Georgia. Please help protect small businesses by saying yes to tort reform. Thank you for your time.
Thank you. Chairman Newton, you have one question?
Hey, I just on behalf of the committee, I want to thank you for being here. I know you represent a lot of your own locations and those that you serve as there are other small businesses. I know it's not easy to come here, but thank you. You put a face to that, especially that over $1 million for criminal activity that you had no way to foresee. And I think it perfectly examples of the reason we need this legislation. But thank you for being here.
Yes, sir. Thank you.
Thank you, Mr. Chairman. Thank you for being here.
Thanks.
I agree with you 100%. I don't think any company should feel targeted for being here. I don't think any of the victims that spoke today or the attorneys, the nonprofits, should have to fear retribution from anyone, nor should any of us for asking questions.
Yeah.
So, and I also want to let you know that I am advertising for Clipper Petroleum almost every day because I have a Clipper Petroleum pin in my desk on the floor, and I use it to sign all my bills. So there you go.
I hope it writes well.
It writes great, and it's lasted multiple years.
Good.
And I appreciate your testimony. It sounds like y'all do a lot of great things that we wish all businesses would do. But you would agree with me that not all C-stores do the things that they should do to keep their premises safe.
I think a majority of us strive to do the best and go above and beyond by providing a safe place, a well-lit facility, having clear windows so that you can see inside and outside the store. But I know that, again, I think it was Mr. Iverson who was up here. Not everybody is going to do that, but I would say that a majority of us are doing the right thing.
And for the minority that don't do the right thing, it's not wrong for us to try to hold them accountable, is it?
No, I don't think it is. But I mean, I also don't think that the ones that are doing the right thing, we keep getting penalized when we are going above and beyond and doing literally all the things that we can, Representative Evans. So we really do need some help, and that's why this is so important
to
us and for small businesses. So
a balance, which means we need amendments, Mr. Chairman. Thank you for being here.
Thanks.
Thank you for your testimony. Bill Custer.
Ladies and gentlemen, representatives, thank you for having me here today. I am your substitute for Justice Blackwell, who could not be here today. I think I'm a poor substitute for Justice Blackwell, but I'll do my best. I'm a lawyer here in Atlanta. I work for Brian Cave, Leighton Paisner in Midtown. I've been practicing law here in Atlanta for 38 years. I was born and raised in Bainbridge, Georgia. Went to Emory and the University of Georgia Law School. I'm not here as an insurance lawyer. I probably sue more insurance companies than I've ever represented. I'm not here for big equity companies. I represent a lot of businesses in Georgia and have throughout my career, both large and small. And there is a consensus among those businesses here in Georgia that there is a crisis in negligent security cases. There is a crisis for a number of reasons. Let's start with the primary reason, which is the status of the law. There is no standard. There's no clearly articulable standard that businesses can follow in Georgia to say, if I follow this standard, I will be protected and I will not be sued. The Supreme Court has articulated this standard, which says that if it's reasonably foreseeable under the totality of the circumstances, then you may be liable. How am I supposed to advise a client on the totality of the circumstances? Well, if I put up lights, will that protect me? No. If I have a security guard, will that protect me? No. If the security guard has a gun, will that protect me? No. We don't know what a jury is going to do with this phrase, the totality of the circumstances, and we do not know how judges are going to advise on that across the state. But what it means really is that businesses, because there's no standard, are going to lose a lot of these cases. I point out, only because it's achieved a great deal of interest in this litigation, Lenox Mall. Lenox Mall has 18 police officers. It has 12 security guards. It has 242 security cameras, and it has a police precinct inside the building, and yet they get sued all the time. I don't claim to know about those cases, but I would think that that would be enough, that would meet the standard, but it doesn't meet the standard. They still get sued. There's no safe harbor for any business in Georgia. Let's talk about the second reason there's a crisis, insurance. The insurers in this market, the commercial multi-peril market, are leaving. They are either gone, like the one that Mr. Iverson read, that insurer's gone, and they're not the only one that's gone. But the others are in what I would call a slow or a fast retreat. And there are a lot of ways they are doing it. One, they are pulling out of high crime areas. They just run a search, and if there's a murder near your building, you don't get insurance. If it's a high crime area generally, and there are a lot of high crime areas in Atlanta, you don't get insurance. If you're a C-store, if you're a bar, if you're a strip mall, if you have anything to do with human habitation, be it condos or apartments or whatever, chances are your insurer has decided not to insure that market for all the reasons we've heard from all of these people who have so bravely come before us today and talked about their experiences. The rates have gone up, not slightly, but 4x, 5x. The retentions have gone up. So you heard that from Waffle House. That is not unusual. $750,000 retention is becoming the standard for many companies like Waffle House. The exclusions and Representative Evans, you asked about SURF. It's not that hard. I'll teach you how to do it. It takes a little trick. I've been through it. There are massive filings of exclusions by the regulated carriers, massive filings. They're excluding assault and battery. They're excluding firearms. There's a broad molestation clause I would encourage you to look at. That is, as we lawyers in South Georgia like to say, broad as the plan of salvation. It covers everything. And the independent brokers, like Mr. Iverson, are seeing those more and more. And maybe they're negotiable, maybe they're not. Increasingly, they're not negotiable. And that brings us to the next problem, to the extent that those exclusions are not negotiable. And that's the only thing you can get. And you got a loan. Every loan covenant in every commercial loan covenant I've ever seen says you have to keep adequate insurance. Every homeowner's familiar with that. You have to escrow your premiums for insurance, and you have to maintain insurance. Now you've got lenders throughout the state of Georgia who have loans on multifamily houses where they may not be able to get insurance that covers assault and battery, that covers firearm-related problems. They're going to be in default of their loan covenants. And if that weren't bad enough, Fannie Mae and Freddie Mac, who have, let me finish on this. Fannie Mae and Freddie Mac, who have, 43% of the multifamily loans in this country, and about the same in Georgia, have said, we're not going to accept those exclusions any longer. And so you're going to be in default with Fannie Mae and Freddie Mac if you have those exclusions in your insurance policy. So you've asked me to wrap it up. I'll wrap it up with that. We have a crisis. We can choose to do something. But if we do nothing, you will make it impossible to improve our communities. If you can't get loans, you can't improve, for instance, the 400 apartment complexes that the Atlanta Journal-Constitution has said are crime-ridden. Forget about getting financing to improve those. It's not going to occur. You'll ensure there's no insurance, essentially, for businesses or victims in these types of crimes, and you will create food deserts. We already have food deserts, but imagine how they will expand if small businesses, who are the only people providing food and pharmacy and other essentials to these communities, if they can't afford insurance. Think about that. That's all I have.
All right, thank you.
I know that the justice would have done better, but if you have questions, I'll try and answer them.
I don't see any questions. What we do have? Oh, Mark, I'm sorry.
Hang on. Just a second, sir.
Yes, sir.
No, I'm not sure about the replacement idea, but I think you did a great job of really explaining something that many of us hadn't even thought of, is the fact that you'd be these exclusions sound like, okay, well, they're excluding one thing out of slip and falls and everything else and fire and everything. But what you described, the crisis and being in default on your commercial loan documents, commercial loan agreements, I think is probably the definition of a crisis for a lot of us who may own some property or may own a business or try to start a business. Maybe not for a multinational firm who self-insures, like we talked about earlier, but for people who do need to carry insurance. And if there's too many exclusions and the mortgage holder says that's not full coverage, now you're in default. And I think you describe a clear crisis that we do need to answer.
Well, it's an evolving one, and it's one that we've been monitoring recently, and I think it's begun to evolve because so many carriers have left the state or left this market. And when you leave this market and you've got one or two carriers and there's no competition, they can impose the exclusions they want to. And I think our goal, and the reason I support the bill, is because I think it will bring back carriers. We have to bring back carriers. If we bring back carriers, we'll bring back competition over terms, like these exclusions, and we'll bring back competition over price. Right now, we just don't have that.
And these carriers didn't leave the state because they were making too much money, did they?
They did not. I mean, Mr. Iverson's absolutely right. I mean, the information is published by AM Best, and it shows that in the multi-peril market, they're losing 130%. I mean, that's their combined loss ratios, 130%. And all of that's, and if you look on the red line, it looks like a ski slope. The trend line is not good.
Thank you, sir.
Thank you. Representative Evans?
Thank you, Mr. Chairman. I first want to thank Mr. Custer for agreeing to help me figure out Georgia Surf, and for the benefit, it wouldn't be the first time he has taught me something, as I spent the first 8 years of my career working with him and his firm, and including cases directly where I remember getting red line briefs. So thank you for teaching me so well.
I don't remember that. I remember them all being perfect.
There you go. There you go. I like that better. But I do thank you for that. A couple of quick questions. You mentioned this crisis has been coming. When would you pinpoint that it started? Where should I start looking?
So it's a good question. I put it at the Six Flags decision 10 years ago. I think I think the Six Flags decision had a profound impact on the way the country saw Georgia's legal system. And the cases that followed that, the Kroger case, a variety of other lesser known cases, and then the CVS case and the Papados case, it's like if you will, like a tsunami that gradually began to get the attention of the country. I can't tell you how these negligent security cases have impacted our reputation throughout the country. I've been in rooms with Fortune 500 representatives from some of the largest companies across the country, and all they talk about are these negligent security cases. They're so horrified by that, it has left a blemish on the whole state.
And you mentioned that a number of carriers have left. I was wondering if you could name those for us.
I can't, but I've got a file where I've got the ones I'm aware of, and I think Mr. Iverson is aware of probably more than I am.
So we can, if I follow up, because I know your email, you can send it to me.
I've got a big notebook of it.
Okay, thank you.
Chair Lady Miller.
Anything else?
Thank you, Mr. Chairman.
Oh,
thank
sorry.
you for coming today.
I keep trying to leave.
I
Forgive
know.
me.
But you just said something that I just wanted to ask you to follow up on. You mentioned the Six Flags case and some of these other cases, and how I guess the jury verdicts in these cases have caused people to wonder what's going on in Georgia. What we've heard in some of this testimony, and what I know from my own practice, is that oftentimes these cases that end up going to jury trial could have been settled for a fraction of the money that the jury ultimately gives, usually within policy limits if the company has insurance. So I'm wondering, why is the conversation centered and placed only on the backs of plaintiffs and injured people for how these quote-unquote verdicts that we just sort of pick out of thin air and describe as being unreasonable without knowing all the facts? Why do plaintiffs have to bear that when usually on the plaintiff's side there have been multiple opportunities for these folks to settle, either within policy limits or for a fraction of what the jury returns?
I have no idea at all what the settlement histories were of any of those cases. I think the cases are attacked nationally and have been attacked nationally because of the facts. For instance, if you look at the Six Flags case, this was a customer who left Six Flags. Six Flags closed. He walked down the street to a hotel. He went to the bathroom. He came back to a Cobb County bus station, and it was at the Cobb County bus station that he was attacked. And people find it outrageous. People, normal people, all over the country find it outrageous that Six Flags was hit for that crime when it occurred 45 minutes after they closed, after he went to another business, and when he then went to government property. It actually occurred on government property. And that case, again, you cannot underestimate the outrageous reaction of insurers, of corporations, and of everyone involved in the legal system when they heard that. That was perhaps the worst case that we've had in the last 10 years.
Okay,
and I can go through every one of them, and I can tell you why every other one of them was outrageous as well.
Sure. But we really haven't heard the true picture of the case in your recitation, because we don't know what why it was determined that the criminal conduct or the death or the serious injury of the person was. But anyway,
I do know. I'm happy to share it with you, but perhaps another time.
That's sure. Another time. We'll be here all day. But I guess I would say, but the Six Flag case, to my knowledge, could have settled for $2 million before trial. Is that true?
I have no idea.
You don't? Okay. Thank you.
With Park.
Thank you, Mr. Chairman. I've been asking a lot of the supporters of this legislation whether or not they think that this is not necessarily an overreaction. Do you think, as some have proposed, an amendment that would exempt victims of sex trafficking, 17-year-olds and 65 years old, those who are 65 and older, would that be appropriate for this?
Well, you know, I can't speak to that. This is the governor's bill. I did read it. I'm not an expert in the whole sex trafficking issue. I read the bill. I saw the carve out for sex trafficking, and I said, good, it's carved out for sex trafficking. Whether that's true or not, I just don't know.
If I may, with respect to the definition of negligent security and the increase, with respect to the definition of negligent security and how they have increased the standards such that, again, it's essentially based on the subjective determination of a property owner, that would clearly, at least in my mind, and I'm not a practitioner here and I'm not a trial lawyer, but clearly, in my mind, that would exclude victims from receiving justice under this legislation.
You know, that's an interesting provision of the bill. Obviously, I didn't write the bill, but the question of whether or not the owner subjectively had knowledge is going to be a jury issue, right? There are going to be people that are going to put on evidence that are going to say he knew, subjectively he knew, and let me tell you how he knew, because he was sued before. The police came and interviewed him about the crime. I mean, there are 1,000 ways that you can show that someone had subjective knowledge. It's not an absolute bar.
Do you think that, again, given the reputation of the state of Georgia and how it's, in your words, been harmed by this 10-year crisis, do you think that that would in any way be undermined if there were explicit protections added to this legislation that would protect victims?
You're talking about sex trafficking victims?
Yes.
Yes. No, listen, I don't think the business community wants to hurt sex trafficking victims. I mean, I would encourage you to go sit down with the governor and figure out what the appropriate carve-out is. I don't know that. I mean, I saw it. I thought it was a great idea for the carve-out. Whether it's effective or not, I have no opinion.
Thank you.
Thank you. You have no further questions. Thank you for your testimony. DJ Mitchell. When you're ready, sir.
Definitely good evening at this point. So, my name is DJ Mitchell. My wife and son and I own 24 McDonald's franchise restaurants in the greater Atlanta area, from Cartersville to Noonan. And like the other 40 plus families that operate McDonald's restaurants in our market, we are regularly defending ourselves against lawsuits. And I wanted to highlight 3 that I currently have ongoing. In 2021, a customer exited one of our restaurants and was struck and killed by another customer driving around the restaurant. And the family of the victim has filed a suit contending that we're liable. In 2022, another restaurant, we have an individual called for an Uber to be picked up in our parking lot at 2 in the morning, and we were closed at the time. And the individual shot and killed the driver and stole the car. The family of the deceased has filed a lawsuit contending that we're liable. In 2023, at another one of our restaurants, 2 customers got into an argument in one of our dining rooms, and ended up one customer shot the other customer, and the family of the deceased has filed a lawsuit contending that we're liable. So we of course have insurance, and McDonald's insurance is probably a little bit different than some of the things that you've heard here. So McDonald's, as the franchisor, requires us to carry a certain amount of coverage. It's standardized across the country. So it's easy to compare quotes when they come in, and we renew every March 1st. And so between January and February, we see the quotes come in, and we're encouraged, obviously, to choose the lowest cost option because it's all the same coverage. In 2022, there were 6 carriers that were willing to offer McDonald's coverage. In 2023, there were 5, and we chose the lowest cost option. It was a 15% increase over 2022. In 2024, there were 4 carriers willing to insure McDonald's franchises. We chose the lowest cost option again, and it was a 24% increase over 2023. I just renewed for 2025. There were only 3 carriers today willing to insure McDonald's franchise restaurants, and we chose the lowest quoted option, which was an 85% increase over 2024. So the pace of increase is staggering, and the rate at which folks are getting out of our market is also staggering. And so I understand that it's your job as legislators to seek a balance, and I very much appreciate the opportunity to share my experience as a small business owner in the market. That's all I have.
Thank you. I don't see any questions.
Very good.
Appreciate your testimony. Thank you for sticking it out with us. And just so Waffle House isn't the only one to get the accolades, I want to say I love y'all's food. I probably shouldn't admit that, but boy, it sure does taste good. All right, Laurel Hart or Hurt? Hart, Ms. Hart. All right. Got one more. And then I was going to let Jeff K go.
I guess it's good evening. My name is Laurel Hart. I think I want to do the disclaimer I've heard here, which is I'm not a lawyer. Makes me a little bit nervous to be up here testifying, but I also think what you're going to hear about our business is we're kind of the poster child for some of the testimony that we've heard today about what can happen to a business owner. For nearly 20 years, I was the director of affordable housing for the state of Georgia. I worked at the Georgia Department of Community Affairs. Following my retirement, I became the asset manager at Columbia Residential. Columbia is a mission-driven developer and owner of affordable housing. We own and manage over 6,000 apartments here in the Atlanta area, and we employ more than 300 people to help us in management of those properties. You may not know Columbia Residential, but some of you may do golf, and you may have heard of Villages of East Lake, which is adjacent to the East Lake Golf Club, which is one of the oldest golf courses in Atlanta. Before there was Villages of East Lake, there was East Lake Meadows, where crime in that area was at 18% of the national average. I think the employment rate there was like 14%. There's a great documentary on CNBC about the revitalization of East Lake that ultimately led to the golf course coming out of bankruptcy. I'm really proud of what happened in East Lake because it really is kind of the story of what Columbia does. We go into some of the worst areas of the city where there's high crime. There's a need for revitalization, and we're committed to making it better. We take on the hardest properties in Georgia with a commitment to the communities and neighborhoods that are here. We also prioritize the safety of our residents. Criminal background checks, community rules, high-definition surveillance, cameras with forensic analysis. I came right from Atlanta Police Department District 3 to be here today, where I was asking for Form 89 to get more patrols at one of my properties. A proactive efforts have made our properties safer, but they certainly haven't eliminated crime at our property. Crime right now is foreseeable almost anywhere you go in Georgia. Who would think crime would be foreseeable at a grade school or a high school? Driving on 85 at Lenox Mall, we all deal with the foreseeability of crime, and we have to handle it in the best way we know, because our tenants are our customers. They're the people that we serve, and anybody that wants to be a good steward of their business is going to want their customers to be satisfied. Proposed changes in Georgia current premises liability laws are sometimes characterized as a choice between economic interests of businesses and individual safety. I don't think that's true. And just so I can go on the record here, I am not a fan of insurance companies or their profits or how insurance is handled here in Georgia. I negotiate all of the insurance for our properties here in Georgia, and it's a mess. Somebody told me once that the view from behind the desk is a lot different from the view in front of the desk. So I want to spend just 2 minutes following up on some of the very good testimony of what it looks like for me. When we talk about firearm exclusions, 146-page policy. I always ask for the exclusions up front. Not uncommon. When does it happen? High crime area. Very, very difficult to get insurance, even if you haven't had much crime in the property, even if you're redeveloping the property, even if you have all of the safety measures that you've talked about. The other place where you get crime is if you settle a case. As soon as we settle a case, even though we have a very large portfolio, we have that exclusion when we do our renewal, which means we no longer have the coverage that we need to meet our investor and our lender requirements. I hear a lot about going in front of the jury, and boy, that would be nice. But insurance companies and insurance defense attorneys don't ask us whether we want to settle a case or not. Often they settle it without even telling us, because really, they are representing the insurance companies and not us. Even if we have no liability and they're very clear about it, even if something happened a block down the street, their recommendation is to settle, because the law in Georgia is so unclear for them and so unsure that settling is better than going in front of a jury. If an insurance company pushes back on a claim, I've had plaintiffs' attorneys come to me, they want me to assign the bad faith claim against my own insurance company. I have to get my own counsel in order to negotiate that. Suddenly, I'm adverse to my insurance company. I'm not going to keep you a really long time, but I can tell you that our company is one of the ones that's got the letter of default that somebody just talked about. Not because we didn't have the insurance that we negotiated when we built the property, but because we don't have the new insurance requirements that Fannie and Freddie are putting into effect. And it's not just about, do you have assault and battery coverage? It's about, do you have 15 million of assault and battery coverage? We're the good guys. I really believe that. We're the ones, most of what you heard today is so terrible, I just can't even get my arms around it. But I'm going to tell you, those people, those owners, the bad guys, I don't think they have insurance, you know, and they're taking their risks if something happens on the property. If there's not a change in the law, it's the good guys that are being hurt the way the system currently operates. Thank you for giving me this opportunity to speak.
And thank you for your testimony. I think you have one question, Whit Park.
Thank you, Mr. Chairman, over here. Thank you for your testimony and certainly all of your prior service to the state. Given your expertise in housing, I did have an evictions-related question. Lines 272 to 274 indicate that if an owner or occupier commences eviction proceedings against a tenant at the time of the wrongful conduct, that they would not be they would not be liable for negligent security. Would that provision increase evictions being filed against residents, in your opinion?
No, I don't think so. I mean, I don't know that evictions could get any worse than what they are right now. I mean, Fulton County is fixing that with the changes in the law, but it was taking us 2 years to evict somebody coming off the pandemic. It still takes us maybe 9 months, but I do think that people that are in the process of being evicted tend not to follow the rules, and there's very little that we as a property owner can do. there's a nexus between crimes and the inability to evict that sometimes I don't think our policymakers have really taken a look at.
And I agree. I think, again, there's certainly bipartisan support to ensure that we're creating an environment for the good actors to succeed. I think we're just being very careful as to the unintended consequences, especially with respect to the most vulnerable among us. So thank you.
Thank you. I don't see any more questions. Thank you very much for your testimony.
Thank you.
All right, Scott Masterson.
Good evening. Is this microphone in a good place? Mr. Chairman, thank you. Other members of the House, and happy to be here even at this hour speaking to you. I will start by saying I was not told the truth about the length of this hearing, but I'm glad that I'll have a little bit of time to talk anyway. I'm the
See what happens when you come down here?
I know now. This is my first time, and it's been a blast. Let me say this: I'm the managing partner at Lewis, Brisbois, Bisgard & Smith here in Atlanta. I grew up in Catoosa County, Georgia. Went to the University of Georgia and got my law degree at Georgia State. I've been handling cases, business disputes, and personal injury cases like we've been talking about here. For about 24 years, and the first half of my career, there weren't any negligent security cases to speak of. That's not to say there were none. It just was a very, very small percentage. There were slip and falls at the grocery store and those type of things. But starting about 2008 or 2009, there's been the development of this litigation. We heard some powerful stories today about deserving people who, it sounds like to me, got deserving justice. And I've represented during that time, as this has increased, both companies that I think are good companies, and I've represented a few that are bad companies. And my job often, in addition to going to trial when I have to go to trial, is to evaluate these cases. And what I want to tell you about the state of the law as it exists is that when clients ask me to evaluate the case, it is very difficult to do so based on some realistic view of the law. And what I mean by that is that the current standard, and you've heard about it, and I know you're familiar with it, this hindsight foreseeability doesn't allow me to give clients who want to do the right thing good advice, and that bothers me. The other thing I want to say about advice on clients, and Bill Custard covered this, so I won't repeat it, is that no one asked me how to do the least. How can I get away with this or get away with that? Even the bad companies don't ask that. When I have companies, though, and I evaluate the case in a situation like we heard today where some hotel owner is condoning or even conspiring and watching it happen in front of their face, I advise them to pay money, and they pay money. I believe that will be true. I believe that's true now, and I believe that'll be true when this is passed. But this does provide clarity, and it provides protection to those good companies, in my view. It also provides clarity on what they can do to do better, not race to the bottom, but what they can do to do better. And the last thing I want to tell you, because I am mindful of the time, is that I heard from some very, very, very good plaintiffs' personal injury lawyers. I heard from some of their clients who've received good results. And I want to say a couple of things about I want to correct a couple of things. Those lawyers have figured out the best way under the current law to represent their clients. Those lawyers, if this passes exactly like it's written now, will find the best way to represent their clients. They are creative, they are coordinated, and there ain't a thing wrong with that, right? And it's not true that they don't advertise for these cases. They absolutely do. There's Morgan & Morgan commercials on the air probably as I'm speaking. They try to get these cases, and unfortunately, while we've heard some stories of some people who really were hurt and probably because of some bad conduct, there's many, many other cases where it's really a head scratcher as to why my client's being asked to defend the case. I mean, I have examples of people shooting into a building from a public road that my client has no control over and just shooting randomly into the side of a building and there's demands made for millions and millions of dollars in that case. And the only way I can think of to prevent it, right, is if you made a bulletproof side of the building. And I could give you examples for hours and hours of cases that I hate to use the word frivolous, but certainly they are not recognizing of what ought to be a reasonable standard in the state of Georgia. And so what I would end by saying is that the cases where there are bad actors, there are going to be lawyers who are going to take those cases to trial. The standards that are here, I've heard several people say they wouldn't take those cases, or they would never be able to get past summary judgment, and it's just not true. I mean, if somebody at Waffle House is going into the stall and sitting in there every day and repeating that conduct every day, and nobody at Waffle House, they know about it and don't do anything about it, they can recover under the statute. It's a crime that they know about that's occurring repeatedly. So this idea that they can't bring a lawsuit under this lines 203 and forward is just not true. And if they can't, maybe I should switch and be a plaintiff's lawyer, because I can.
All right, Representative Evans.
Thank you, Mr. Chairman. Thank you, Mr. Masterson. Go Tigers.
Go Ringgold Tigers.
We're survivors of Ringgold High School in a good way. We had great teachers and had a great example in how to get to law school in Mr. Masterson, and I appreciate that. And thank you for being here. You mentioned that we heard from some good plaintiffs' lawyers today, and I agree with that. I don't agree with your statement that we'll just find a way. And your last comment sort of gives me an example I want to throw back to you. You know, if people are going into the stall at Waffle House and people are coming out in bathrobes and screaming that somebody's assaulting me, how is that crime committer taking advantage of a physical condition? Because that is, I think you would agree with me, a requirement now. There's got to be an exploitation of a physical condition on the premises in order to get to these negligent security claims, and that's on line 225. And so tell me how you, and I believe you're a good lawyer, how would you do that? What's the specific physical condition?
Well, I guess there is a location that is private or out of the view of the management of the restaurant, and that if that condition is being used to hide some type of criminal activity and Waffle House becomes aware of it and fails to do anything about it, then I would think that you could proceed against Waffle House under the 51-3-51. I mean, it's a little bit more than the physical condition. Prior occurrences of substantially similar wrongful conduct upon the premises, which the owner or occupier knew.
Right, those are ands. We've got to get a specific physical condition and knowledge and I think there's several. But if a bathroom stall being out of the view of the public is a specific physical condition that someone is taking advantage of, then aren't y'all going to be in here next year telling us that every restaurant is now vulnerable? Because I hope every bathroom stall is out of the view of the public.
I'll bet you a nickel that the argument on what a physical condition is as it relates to presenting a hazard or risk on a premises is going to be argued to be very expansive by you and your fellow plaintiffs' lawyers.
Well, given that, do you agree that it's important that there be balance in the law so that good cases can make it past summary judgment?
I think that's the whole point of this.
Do you think that this law that we've got proposed in front of us right now could use some work to potentially be more balanced?
I'm not, as you know. I've not run for public office. I missed the Georgia State Law School legislative drafting class. My job is to make reasonable arguments from the law, not draft it, so I'm going to pass on that question. I would say that probably any piece of legislation in the history of the world could have been better drafted in some ways, but as this is drafted, I think it's intended and does create much more balance that exists now.
If we were to get to the point where amendments were to be taken, recognizing that no legislation draft is perfect, particularly when it's drafted behind closed doors and then thrown out to everyone, if there was a concerted effort put together to try to improve this, would you be willing to be part of those efforts to try to make it better?
I'd do anything I could to serve the great state of Georgia.
Thank you.
Thank you. I don't believe you have any further questions.
Thank you, Chair.
Thank you for your testimony. Senator Kennedy, I know it's late. Would you like to respond or close us out, or do you want to wait and do that at a different meeting? What's your preference? Well, yeah, given the hour, maybe we could do that because we're going to be back right at this tomorrow afternoon. So if that's all right, maybe we'll just try doing that then, because I know everybody probably wants to get home and eat some Waffle House or McDonald's somewhere. So. Yes, ma'am.
Could you give us a little bit of what you expect to be the work from here?
Well, at this point, I know we will meet tomorrow, and we're going to talk about the two last sections of the bill, and at that point, I'm not exactly sure when we'll meet again, but it's going to be hearing only tomorrow, and then we'll try to schedule another meeting to start chatting about the bill and making some decisions.
Do you have any idea about this week or next week?
Of what now?
Do you have any idea whether that next meeting would be this week or next week? This week?
I think it's likely to be next week. Thank y'all. Thank you, everybody. We're adjourned.